Needfully stated to have been done, registered to look into. Next.
Well, the office objection may be overruled since we have served to the KIDB respond number 3 on 10th itself, madam. And regarding that, we have filed the memo of acknowledgement.
Who appeared for KIDB? Pradeep Kumar. Sri H.L. Pradeep Kumar is requested to accept notice for response number 3 KIDB na?
Yes, madam.
KIDB. Pradeep Kumar mat karkomandra next week ಏನೋ ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
They are only formal
Please,
parties, they were co-respondents, my lord. The review petition is filed as the writ petitioner. I am the contesting respondent and state.
And we have not been served the copy of the statement of objection they have filed, madam.
ಹೌದಾ?
R4 has served.
ಆಯ್ತು ಕೊಟ್ಟು ಇನ್ನೊಂದು ಕೊಟ್ಟು.
Give another one.
Call after
Please.
2 weeks.
Online serve.
ಆಲ್ಪೇಟಿ ಇನ್ನೊಂದು ಕೊಡಿ. ಅದು ಅಷ್ಟು ತಲೆ ಕೆಡಿಸಬಾರ್ದು ಅದ್ರ ಬಗ್ಗೆ. Yes. Next. Call after 2 weeks. Okay.
Date, my lord, next week your lordship says. Any date?
Next week we have a difficulty.
No, whenever
Because
date.
your matter is also.
No, whatever date your lordship gives.
2 weeks ಮಾಡೋಣ.
Please.
After March 10th, madam.
Anyway, it will come after March 10th, 3 weeks.
Please.
3 weeks, okay.
Needful will be done in the course of the day, today.
To be done in the course of that. Public. Failing which, heavy costs would be levied on the next date of hearing. Yes. Please. Yes.
Well, this is again delay 15 days delay. The delay meant to be confirmed, my lord.
On ಮಾಡ್ಕೊಳ್ಳಿ.
On it. On it.
ಹಾ.
Delay need to be confirmed, my lord.
Lieutenant DG is requested to accept notice for respondent revenue.
Copy maybe.
First up, or copy ಕೊಡಿ. Appeal is filed after booking a short delay of 15 days. First up, an application supported by affidavit accompanies it. First up, Lieutenant DG opposes the application. First up, however, delay being too short to be lethal and apparently matter having some merits, comma, application needs to be allowed and accordingly it is, and delay is condoned. Okay.
Serial number 4. Next matter.
Same order,
Same.
3 days is it. Call after 2 weeks.
Meantime, if my land friend gives a copy.
Copy ಕೊಡಿ ಅವರಿಗೆಲ್ಲ.
Ready for admission.
ಎರಡೆರಡು ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಇಷ್ಟು 2 ಸೆಟ್ ಕೊಡ್ಬೇಕು ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾಕಂದ್ರೆ ಅವ್ರು ಒಂದು ಇಟ್ಕೋಬೇಕಾಗ್ತದೆ ಒಂದು ಗೌರ್ಮೆಂಟ್ ಕಳಿಸ್ಬೇಕಾಗ್ತದೆ ಅದಕ್ಕೆ. ಓಕೆ. Yes.
I'm seeking the continuation of delay of short delay of 2 days. I was under the impression that if it's filed on the first day after the vacation, it would be rejected.
Matter.
I'm also seeking a stay on annexure A, your lordship.
Notice and stay. Learned AG is requested to accept notice for the respondent. First up, ಅಲ್ಲಿ delay ಇದೆ ಅಲ್ಲ 2 days. Same ground matter. Okay. Yes.
Same order, your lordship. I'm seeking a stay, but there's no delay.
No delay.
No delay. But
Notice ಹೋಗ್ಲಿ. Notice ಹೋಗ್ಲಿ. AG issue notice. Learned AG is
Your lordship,
requested
if I
to
may
accept
state
notice
some
for
facts.
respondent. ಏನಿದೆ urgency ಏನಿದೆ?
Your lordship, because the end of the year demand where they'll go for recovery. Your lordship.
Interim order as prayed for in the application till next date of hearing.
Even the previous case similar, your lordship.
ಅಲ್ಲಿಯೂ ಹಂಗೆ ಮಾಡ್ಬೇಕು. Okay. Yes.
Grateful.
Yes. ಇದನ್ನೊಂದು ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಒಂದ್ ಯಾವ್ದೋ ಒಂದು ಕನ್ಸ್ಯೂಮರ್ ಮ್ಯಾಟರ್ ಇದೆ. ಆಮೇಲೆ just you can have coffee round and come back.
Yes.
Come back. We'll send words to you. Yes.
This matter, commission ordered by your lordships was executed. Spot inspection was made. There's a draft report in circulation amongst the members of the commission. I do not wish to file it in a hurry. I want my learned friends to weigh in on the draft report. If the commission is given time until Monday, report will be before your lordships.
Okay.
In sum and substance is, my lords, we compared the state of the apartments to a specifications sheet that was given to us by counsel for the petitioner. Substantially, in my view, the apartment resembles the what is provided in the specification sheet. That said, your lordships had also mentioned in open court about habitability. There are certain issues, for example, flooding, nexus to a stormwater drain, wall is demolished because of encroachment. Substantial cleaning, de-weeding has to be carried out. There is no water supply in any of the apartments.
No water supply.
There is no water supply. Various reasons are cited. Somebody says there is no water connection at all. Somebody says everything is there, but motor today fuse is not working. So so all that will.
Aleno, people were residing there already?
No, my lords, it is vacant.
Vacant.
All apartments inspected are vacant. There were two lists of apartments, one that has been given to the purchasers and one that is said to be retained by the petitioner. There is a difference between the state of completion on what is given to the petition, to the purchasers and what is retained, said to be retained by the purchaser, by the petitioner. The purchaser's apartments are, when compared to the specifications, are in a substantial state of completion. Some taps are missing, false ceiling in some places is missing. There is a lot of dirt, cobwebs, pigeon feathers, pigeon droppings, etc. Adarna ella id madbeko. But no deviation from specifications was pointed out. That is the
Deviation ಏನilla.
from the specifications. Deviation from sanction plan, deviation from buffer, etc. That
That is for the
DPMP
authorities
yes,
to decide.
yes.
Okay.
There are some observations regarding pillars. Some of them appear to be tapering. Given that there was no time between the not sufficient time between the inspection and the order copy being made available, we have made an observation that some of these may have to be looked at by a structural engineer. Visually, what we see, we have observed.
Would you take assistance of any engineer with you?
Well, it's not
Time
on.
was short.
Time was short. Neutral engineer was not available. There was a engineer who was said to have been involved in the execution of the project who was available, but we did not find his assistance compelling on that day. So some observations will we will submit that they will require some technical investigation.
ಅಲ್ಲ ರಿಪೋರ್ಟ್ ನೀವು ಅನಾನಿಮಸ್ಲಿ ಕುತ್ಕೊಂಡು ಡಿಸ್ಕಸ್ ಮಾಡಿ ಫೈನಲೈಸ್ ಮಾಡಿ ಹಾಕ್ಬೇಕು.
My learned friend is in dual capacity
ಹಾ.
as.
No, because of his fairness, we appointed him. Both are like that. That gentle lady is like that, and so panel counsel is also like that. They do not, they are having their head on shoulders. That's the reason we have made them. Yes. Otherwise, generally, those who appear in the case, we do not appoint as commissioners at all. That's the reason we said that. Yes.
In fact,
So-
these engineers were present, a lot of cooperation. Everybody cooperated. my lord.
Okay. ನೀವು ಒಂದು ಇವತ್ತು ರಿಪೋರ್ಟ್ ರೆಡಿ ಮಾಡಿ ಅದ್ರ ಕಾಪಿನ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೂ ಕೊಟ್ಬಿಡ್ತೀವಿ. ಸೊ ದಟ್ ಅವ್ರದ್ದು ಒಂದೇನೋ ಯೂಸ್ ಇರ್ತದೆ ಅಲ್ವಾ? ಒಂದು ಇವ್ರಿಗೂ ಒಂದು ಕೊಡಿ,
ಅವ್ರಿಗೂ ಕೊಡಿ.
ಅದೇನು ಮುಚ್ಚಿಟ್ಕೊಳ್ಳುವಂಥದ್ದು ಏನಲ್ಲ. ಇಟ್ಸ್ ಅನ್ ಓಪನ್ ರಿಪೋರ್ಟ್
It's an open.
ಫಾರ್ ವಿ ಕ್ಯಾನ್ ಹ್ಯಾವ್ ದಿ ಕಮೆಂಟ್ಸ್ ಅಂಡ್ ಗಿವ್ ಇಟ್ ಟು ಪಾರ್ಟ್ನರ್ಸ್ ಹೂ ಆರ್ ಹಿಯರ್ ಇನ್ ಒಬಿಡಿಯನ್ಸ್ ಟು ಆರ್ಡರ್ ಆಫ್ ದ ಕೋರ್ಟ್. Okay.
My lord.
All right. We'll call this matter on Monday.
Tuesday minutes, Monday.
Tuesday? ಅದೇ ಟ್ಯೂಸ್ಡೇನ ಆಗಲಿ. ಟ್ಯೂಸ್ಡೇ ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಬಂದ್ಬಿಡಿ. ಅವತ್ತಾ? ಟ್ಯೂಸ್ಡೇ ಏನ್ ತೊಂದರೆ ಇಲ್ವಾ? ಓಕೆ, ನೋ ಇಶ್ಯೂ. ಅವತ್ತಿನ ದಿವಸ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇರಕ್ಕೆ ಹೇಳ್ಬಿಡಿ, ಆರ್ಡರ್ ಮಾಡೋದು ಬೇಡ. Because they appear to be respectable people. They are here. Other day also they were here. Today also they are here. Okay? Okay.
As regards
ಅದನ್ನ ಆಮೇಲೆ ನೋಡೋಣಂತೆ ಉಳಿದಿದ್ದು. ಮೊದಲಿಗೆ ಕನ್ಸ್ಯೂಮರ್ಸ್ ಎಲ್ಲರಿಗೂ ಮನೆಗಳು ಸಿಗಬೇಕು. ಫಸ್ಟ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ದಿ ಕ್ವಾರ್ಟರ್, ಕನ್ಸ್ಯೂಮರ್ಸ್ ಎಲ್ಲರಿಗೂ ಮನೆಗಳು ಸಿಗಬೇಕು. ಆಯ್ತಾ? ನಿಮ್ ನಡೆಯಿರುವಂತ ಡಿಸ್ಪ್ಯೂಟಿಗೆ ನಾವ್ ಏನ್ ಮಾಡ್ಬೇಕು ಅದನ್ನ ನಾವು ಥಿಂಕ್ ಮಾಡೋಣ. ಪಾಪ ಅದರಲ್ಲಿ ಅವ್ರನ್ನ ಯಾಕೆ ಸಿಗಿಸ್ಬೇಕು ನಾವು? ವೈ ದೇ ಶುಡ್ ಸಫರ್? ದೇ ಆರ್ ಆಲ್ ಇನ್ನೋಸೆಂಟ್ ಪೀಪಲ್ ಅಂಡ್ ಯು ಆರ್ ಆಲ್ ಮೈಟಿ ಪೀಪಲ್. They are not a match. They are sufferers. At times they are sufferers. At times they are intentionally made to suffer. At times incidentally they suffer. We do not know in which category case falls, but suffering as such is there. Suffering. Suffering ಆಗಿದೆ. 10-12 ವರ್ಷ ಅವ್ರಿಗೆ ಕಾಯಿಸಿದ್ರೆ ಕೋರ್ಟ್ ಮೇಲೆ ನಂಬಿಕೆ ಏನ್ ಬರ್ತದೆ? ಅವ್ರಿಗೆ ಖರ್ಚು ಮಾಡ್ತಾರ ಅವ್ರು, ಜಡ್ಜೆ ಸಿಗಲ್ಲ. ಅದೇ
ಇನ್ನೊಬ್ರು ಪ್ರೆಸೆಂಟ್ ಇರ್ತಾರೆ.
ಬೇಡ, ಇಬ್ರು ಬರೋದ್ ಬೇಡ. ನಿಮ್ ಲಾಯರ್ ಇದ್ರೆ ಸಾಕು. ಬಟ್ ಇವ್ರು ತಗೊಳ್ಳೋ ಡಿಸಿಷನ್ ನೀವು ಒಪ್ಬೇಕು. ಆಮೇಲೆ ನಮ್ ಲಾಯರ್ ಸೈನ್ ಮಾಡಿಲ್ಲ, ನಮ್ ಕೇಳಿಲ್ಲ, ಇದೆಲ್ಲ ಕತೆ ಕೇಳಲ್ಲ ನಾವು. ಇಫ್ ಅಟ್ ಲೀಸ್ಟ್ ಒಬ್ರು ಇದ್ಬಿಡಿ. ಓಕೆ, ಇದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ, ನಾವು ಹೇಳೋದು. ಬಟ್ ದ ಕಮಿಷನ್ ಅಪಾಯಿಂಟೆಡ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅಕಂಪ್ಲಿಷ್ಡ್ the task in an appreciable way and within the shortest possible time. First up, the report of the commission is being vetted. First up, a copy thereof shall be furnished to all the stakeholders to have their say on the same. First up, court has noted the presence of our ಹೆಸರೇನು ಎಂತ so and so pursuant to order, pursuant to direction. First up, presence is appreciated. Presence today is also appreciated. Their presence today is also appreciated. First up, on the next date of hearing, one of them shall be present before the court to take decision on behalf of other also. First up, the baseline of the case is that the justice has to be done to the consumers first, regardless of the dispute between the partners inter se of the firm. First. Okay. All this matter for further hearing on Tuesday. On Tuesday. ಯಾರು ಏನಾದರೂ ಹೇಳಲಿಕ್ಕಿದೆಯಾ? ನಿಮ್ ಕ್ಲೈಂಟ್ ಏನಾದರೂ ಮಾತಾಡ್ಲಿಕ್ಕಿದೆಯಾ?
Not for. On the issue of the sale deed, my lords had asked about the sale deed, my lords.
ಅವನು ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಮಾಡಿದ್ರಿ?
My lords, we have given, most of the comments are acceptable. There's only one issue, my lords, regarding they want to hold the firm liable and go against the assets of the firm. That is all, that recital we had put in the sale deed. That issue, my lords have to look into it on Tuesday, my lords. Because if that issue is resolved, then my lords, most of the terms of the sale deed, many of them are acceptable to us. Few, they had raised certain things, we have given justification as to why that clause is there.
ಈಗ ಆ ಒಂದೇ ಕಂಡೀಷನ್ ಬಗ್ಗೆ ನಿಮಗೆ ಇಶ್ಯೂ ಇದೆಯಾ?
ಅಲ್ಲ, ಜಸ್ಟ್ ಫಾಸ್ಟನಿಂಗ್ ಲಯಬಿಲಿಟಿ ಅದನ್ನು ನಮಗೆ ಅಬ್ಸಾಲ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೊಂದು ದಟ್ಸ್ ದಿ ಓನ್ಲಿ ಥಿಂಗ್, ದಟ್ ಇಸ್ ಫೋಕಲ್ ಪಾಯಿಂಟ್ ಆಫ್
That, my lords, we'll make our submissions.
There's an express rider that the consumers will not have any claim over the third judgment debtor and the firm. Some substance of the disagreement is there.
My lords, I'll file an affidavit regarding whatever is, whatever expenses, etc. is incurred.
column.
I'll file an affidavit.
Learned counsel for the petitioner submits that learned counsel for the petitioner and the learned counsel representing the consumers submit that the draft sale deed with the appropriate modifications have been broadly finalized subject to one condition as to absolving of the firm and the petitioner herein from being proceeded against in terms of the order in question.
Delay compensation.
Huh?
Delay compensation.
The order.
What is the order in question? Question. First, This aspect would be considered on the next date of hearing. Okay? Ah,
My sincere apologies, my lord, 27th.
27th, ಅಲ್ಲಿ.
Okay, Thursday.
ಯಾಕೆ ಮಂಗಳವಾರ ಬಂದ್ರೆ ಸ್ವಲ್ಪ
Malad,
ಇವೆಲ್ಲ
I'll be traveling-
ಬೇಗ ಮುಗಿದು ಹೋಗ್ತದೆ. ನಿಮ್ಗೆ ಏನಾದ್ರು ತೊಂದ್ರೆ
I'll be
ಇದೆಯಾ?
traveling to Prayagraj, my lord, 25th and 26th.
Okay. Okay. All right. 27th ಹಾಕೊಳ್ಳಿ.
Great.
ಆಗ್ಬೋದಾ?
Just check with Mr.
ನೋಡ್ಕೊಳ್ಳಿ, ಕೇಳ್ಕೊಂಬನ್ನಿ. ಮಾಡಿ, ಇಲ್ಲೇ ಫೋನ್ ಮಾಡಿ, ಕೇಳಿ.
I think he's on his legs in 27. So
ಹಾ,
I'll just
ಹೋಗಿ ಕೇಳ್ಕೊಂಬನ್ನಿ. Okay.
27th, I think he was available. But if there's anything, I'll request the court. I'll check with my learned friend also for a date and I'll request.
ಅಲ್ಲೇ ಆ ಕ್ವಶನ್ ಅದರ್ ರಿಲೇಟೆಡ್ ಕ್ವಶನ್ಸ್ ಆಲ್ಸೋ ವಿಲ್ ಬಿ ಅಡ್ರೆಸ್ಡ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ ಅದರ್ ರಿಲೇಟೆಡ್ ಕ್ವಶನ್ಸ್ ಹಿಂಗ ಅನ್ಬೋದು ವಿಲ್ ಬಿ ಅಡ್ರೆಸ್ಡ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಇದೆ ಅಲ್ಲ ಅಲಾಂಗ್ ವಿತ್ ಅದರ್ ಇಶ್ಯೂ ಬಟ್ ಅವರಿಗೆಲ್ಲ ಸೇಲ್ ಡೀಟ್ ಸಿಗಬೇಕು ಸಾಧ್ಯ ಆದ್ರೆ ಇಲ್ಲಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಇಲ್ಲಿಗೆ ಕರ್ಸಿಬಿಡ್ತೇನೆ ನಾವು ವಿಲ್ ಡೈರೆಕ್ಟ್ ದಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಟು ಕಮ್ ಹಿಯರ್ ಅಂಡ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಟು ಹ್ಯಾಪನ್ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಅವರ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಟು ಸಿ ದಟ್ ಅಟ್ ಲೀಸ್ಟ್ ಡ್ಯೂರಿಂಗ್ ದೇರ್ ಲೈಫ್ ಟೈಮ್ they will see the sale deed and they occupy the building.
27th is
27th, call on 27th for further hearing. ಉಳಿದಂತ ಕನ್ಸ್ಯೂಮರ್ಸ್ ಎಲ್ಲಿದ್ದಾರೆ ಮತ್ತೆ ಅವ್ರು ಇನ್ನೊಂದು ಸೆಟ್ ಕೇಸ್
ಬೇರೆ ಬೇರೆ ಕಡೆ
My lord,
ಬೇರೆ ಬೇರೆ ಕಡೆ ಇದ್ದಾರೆ.
my lords, there is some 32 people, my lords. I think my learned friend has been kind enough to get their details and give it to us. There are totally 50, my lords, the cooperation of respondent number
But he is privy to all the sale agreements.
privy to all the, if he can get, my lords, respondent number 2 can get the rest of the consumers here, my lords, will be great, because we have no access. All agreements have been signed by respondent number 2, not by us. We are not aware of any of those people.
ಕೇಳಿ ಮಿಸ್ಟರ್ ಪ್ರಭು.
ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಅವ್ರಿಗೆ ಫರ್ನಿಶ್ ಮಾಡಿದ್ರು ಲಾಸ್ಟ್ ವೀಕ್. He will also try to contact them independently and ask them to come.
No, addresses were not there. In the
Ale-
details furnished, addresses and phone numbers were not.
ಅಡ್ರೆಸ್ಸಸ್ ಈಗ 1:30 ಒಳಗಡೆ ಅಡ್ರೆಸ್ ತರಿಸ್ಬಿಡಿ.
And we need copies of the sale agreements. We
ವಿಲ್
need-
ಸೆಂಡ್ ದಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್ ಟು ದೆಮ್.
Copy email ಮಾಡಿದ್ದಾರೆ. Will furnish copies of all the agreements.
ಕಾಪೀಸ್ ನಮ್ಗೆ ಅಡ್ರೆಸ್ ಅಷ್ಟೇ ನಿಮ್ದು ಅವನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ನಾವೆಲ್ಲ ಮಾಡ್ಕೊತ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಬರೀ ಅಡ್ರೆಸ್ ಆಫ್ ಆಲ್ ದಿ ಕನ್ಸ್ಯೂಮರ್ಸ್ ನಮ್ಗೆ ಕೊಡಿ. ಮತ್ತ ಅವ್ರು 10 ವರ್ಷ ಒದ್ದಾಡೋದು ಬೇಡ ಅಂತ ಅದಕ್ಕೆ
54 persons.
54 ಮೂರು ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅಂತ ಸೇಲ್ ಡೀಡ್.
ಆ?
54 ಅಗ್ರಿಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಮೂರು ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ.
ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. ಅವರು ಕೇಸ್ ಏನಿಲ್ಲ ಮತ್ತೆ
ನ್ಯಾಷನಲ್ ಕಮಿಷನ್ ಎಲ್ಲ ಹಾಕಿದ್ರು ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ.
ಆಗಿದೆ.
ಒಂದು ಹಾಗೆ ಔಟ್ಸೈಡ್ ಕೋರ್ಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ.
ಇಲ್ಲ ಇಲ್ಲ ಮೂರಾಗಿಲ್ಲ. ಒಂದು we paid the money to that consumer and he has agreed that insofar.
ಅವ್ರಿಗೂ ಕಳಿಸ್ಬೋಣ ಅವ್ರನ್ನ ಕೇಳ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡತ್ತ ಯಾವ್ದು ನಿಜ ಅಂತ. 50 ಜನರಿಗೆ ನೋಟಿಸ್ ಕಳ್ಸೋಣ ಅಂತ.
ಇಲ್ಲ ಅದೇ agreement copy we don't have.
ಬೇಕಾ?
Agreement they have. R2 has agreement. He has not furnished it to us.
ಯು ವಾಂಟ್ ದಟ್ ಕಾಪಿ?
Agreement copy.
Agreements copy ಕೊಡಿ. Next paragraph. The respondent Prabhu brothers are hereby directed to furnish copies of agreements and sale deeds, if any, which are said to be 50 in number, 54 in number, to the counsel for the petitioner by email today. Email before sunset of the day.
With a copy to us also.
None
The
cus- none
association.
ಸಿಕ್ಕಿದ ತಕ್ಷಣ ಕಳ್ಸ್ತೀನಿ.
To the petitioner and to the learned counsel appearing for the consumers. This day itself. First up. Petitioner is directed to mail this order to all the consumers if mail addresses are available. Or at in semicolon. If addresses are not available, comma, the gist of this order shall be informed to all the consumers over phone and by message to mobile phones of the consumers immediately.
Details ಕೊಡ್ಬೇಕು. Phone numbers and for 32 people we have.
ಅದ ಈಗ ಅಗ್ರಿಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ಇದ್ಬಿಡ್ತದೆ.
ಎಲ್ಲ ಬಂದು.
ಅದನ್ನ ತೊಗೊಂಡು ಕಳಿಸೋ. This exercise shall also be accomplished by respondent Prabhu brothers. Brothers as well. As well. First, next paragraph. Non-compliance of this direction may lead to stringent action against the violators. Which may include possible arrest and detention. Yes. Yes.
For the respondent number 3 and 4, my lord. Yes.
ಯಾವ್ದಿದು? ಏನು? Yes, madam.
Kindly, my lord. There is a dispute in respect of a site
Ah.
in Chickenhalli village,
Ah.
measuring to an
You are,
extent of.
you are for
I'm
complainant.
for the, I'm for
Complainant.
the 3 and 4, my lord.
Are you for complainant?
No, my lord.
You are, who are you?
I'm for the panchayat and the executive officer.
Panchayat and executive officer. Where is this council for Subhash Shastri? Where is Subhash Shastri? Password. ಒಂದೊಂದ್ಸರಿ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಏನೋ ಹೋಗಿರ್ತಾರ ನಾವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ಸ್. ಎಸ್ ಬಟ್ ಪ್ಲೀಸ್ ಕಮ್ ಸರ್ ನಾರಾಯಣ. ಹಾ ಇದನ್ನ ಆರ್ಡರ್ ರೆಡಿ ಮಾಡಿ ತೊಗೊಂಬಂದು ಕೊಟ್ಬಿಡು, ಬೇಗನೆ ಸೈನ್ ಮಾಡಿ ಕೊಟ್ಬಿಡ್ತೇವೆ. ಹೋಗ್ಬಿಡು. ಹಾ ಎಸ್ ಕೊಡಿ.
The
Ah.
facts of this case, my lord, Division Bench of Justice Jain Patel and Justice Satyanarayana are in paragraph 2.
ಮಾನಸ.
Manas elected. Short facts of the case are that the appellant assessee filed the returns for assessment year 5-6 and a particular amount of tax payable was shown in the returns. Assessee did not file revised return within the prescribed period of 6 months, but filed the revised return after the expired period of 6 months. In the revised return, net effect was not the liability to pay any additional tax, but was the refund claimed of a substantial amount by showing that the input tax credit was higher than the tax payable. Assessing authority assessed the returns, but did not accept the revised return since it was outside the period of 6 months. And
This
hence
is about limitation,
it is about limitation,
not about claiming it in the return or not.
claiming it in the return.
That's not.
My lords.
They said there is a limitation.
What happens in this case, my lord, is a circular that is issued by the department on returns is examined by the honorable court. Your lordship may kindly come to para 12, where 35 is extracted. Thirty-five is extracted 4 AB,
Para 12.
para 12.
It is also brought to our notice.
No, my lords. Para 12, in order to appreciate the contentions.
Page 3. Extracted portion. You are right. Yes, para 12.
Para 11, my lords, the contention is, here, my lord, it is a case of revised return, but outside the time limit. Your lordships are absolutely right.
The first contention raised by the subject,
The first
even after the expiry of period of 6 months. So it's on limitation period.
Then 12 is extracted.
Of course, that point also he has raised.
Also,
Yeah.
also.
They said there is 6 months limitation. What's the answer? They held in the affirmative.
And in what circumstance can after 6 months, can it be accepted? In order to
But
appreciate.
in this case, whether it is beyond 6 months,
Well beyond 6 months, well beyond 6 months.
is it on beyond 6
Well
months?
beyond. That it was picked up for assessment well beyond 6 months.
6 months is to be reckoned from which date according to law?
If I four itself says that if the SSC finds any omission, he has a remedy of filing a revised return within 6 months.
Of
That is
the-
the 6 months that my learned friend and his judgments are applicable.
Of the relevant tax period.
35(4) itself, my lords have seen section 35. 35(1) provides the original return. If there are any mistakes noticed in the return, the SSC has an option of filing a revised return under 35(4) within 6 months from the tax period. So within 6
That
months,
period, according to you, that period is not for seeking refund, the adjustment at all.
the main dispute between the revenue and the
Indeed, this
SSC
one.
mainly is,
No, two questions.
I realized that mistake much later.
No, that I understood.
Time for filing revised return is over. Yeah, that I am not disputing. I am not saying that we have filed revised returns or the time for filing the revised return is also over. But during the course of assessment, whether a claim or a benefit that has been given to me under that can be made and can the assessing officer consider it is the question.
One, incidentally, whether limitation for filing revised return is applicable to for claiming input adjustment or not. That way. In contention, if legislature intended, it would have said so. Anta.
From day one, the department wants to read 10.35 and rule 38 as a composite. That's his.
That's the stand also.
They want to read it as a composite listing. Whether that can be done, because as per our submission, 10 is a substantive provision, 35 and rule 38 are machinery provisions. Machinery provisions cannot take away. rights.
Yes, you have said that. Yes. So 11, para 2, 11, 12. Correct.
My lord, 2, 11, 12.
Where circular is mentioned.
Yes. Your lordships will then come to 13. At this stage, we may usefully refer to the decision of this court in STA 2 of 2016 allied matters, decided on so and so in the case of Jones Lang LaSalle versus State of Karnataka. In the said decision, it was brought to our notice that the commissioner had issued a circular dated July 7, 2008, whereby the revised return could be accepted after the expiry of 6 months if it was to result in additional tax liability. In the said case, to revised return was partly accepted so far as additional tax liability was concerned, but was not accepted for the credit of input tax. In the said case, the revised return ultimately, even after additional input tax credit, was resulting into net additional tax liability. This court at paragraphs 5 to 15 observed thus. My lords, the aspect is examined, whereas the position of the department was that pursuant to 35, I can accept a return if it is in the interest of the revenue, if he's offering additional amount of tax.
This very one-sided decision appears to be very, very one-sided. One-sided held by this court. ಗೌರ್ಮೆಂಟಿಗೆ ಬರಂಗಿದ್ರೆ ನಾವು ಅದು ಮಾಡ್ತೀವಿ, ನಿಮಗೆ ವಾಪಸ್ ಕೊಡೋದಿದ್ರೆ ನಾವು ಮಾಡಲ್ಲ ಅನ್ನೋದು.
He has to be,
ಜಸ್ಟಿಸ್ ಎಲಿಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅದು.
he has to be diligent and vigilant of his rights.
That's right. That applies to state also. So when you are saying that whatever is due to me, we, for that we will extend period. Whatever due to him, we don't give that benefit. Anyway, all right.
Then minutes 13. The
Centum.
centum is extracted. Then my lords, over the page 14 of this judgment. If the provision of 35(4) of the vide Act is read and considered with the above referred decision of this court, it may be said that if revised return is filed after expiry of 6 months, but is to be ultimately resulting in next.
That is, Lassalle is reiterated.
Yes. Yes. Then admitted position that in the present case, revised tax return was for claiming higher input tax credit, but the net effect was not for additional tax liability, it was for refund of the amount. Therefore, even if the interpretation is considered as made above by this court in the above decision read with the above circular, same would be of no help to the appellant, so and so. Para 18 months. The lordships are para 18. In our view, even if principally is accepted that the input tax credit can be claimed irrespective of the month in which the selling dealer raised, then also there is no express reading down of section 35(4) of the VAT Act, providing for outer limit to file the revised return, coupled with the power with the prescribed authority to accept at a later stage, if it is so decided by way of policy. In any case, since the state has not accepted the order of the single judge, so and so forth. And therefore, my lord, here the court comments on my policy that there is no reading down of 35(4). Even a revised return in the prescribed form cannot be accepted. Here we have the case.
Even if you had filed one, your contention is
No,
for any claim, it has to be in the return
none of
or at least in the revised return. If period for filing the revised return is over, then question of claiming will not arise.
Lords, before looking at the other judgments, I have one or two to submit. One aspect was bothering me, which is that the contentions before the tribunal and before the SMR authority, Sumo Revision Authority, is replete with inadvertence, bona fide, mistake, overlooked, etc., etc. If it is a matter of right that you can walk in up to the stage of the tribunal, where is the question of inadvertence, bona fide, I did not look at 14, I only looked at 11, under mistake of law or ignorance of law is no excuse. He raises a ground in equity to show himself as a honest boy, which anyway in India agencies is dealt with. India agency says even an honest dealer can suffer, but the object of these provisions is to ensure protection of revenue and that fraud should not be perpetrated. But the ground that he says this is inadvertent, I was under the bona fide belief, I looked at 11, I did not look at 14, etc., etc., is not the language of one who is invoking an unfettered right. He wants to somewhere invoke equity so that when it comes before this court says, all right, is that it? Inadvertent. Your chartered accountant was not well for a few days. We will grant it.
But input as such, he has mentioned in the returns.
Please, my lord.
Rates, so far as rates are concerned, his grievance.
With that rates comes because I give a rebate under 14 as an exception to the prohibition in 11. He says I did not look at 14 or did not realize that it was falling within 11, 5 and 6, which is covered by 14. And there is an explanation that it is in inadvertence and in good faith. Why is that explanation necessary if it's a matter of right? There is no explanation necessary.
In a citizen, some explanation. It is like a frill to the frock. For frock, frill is not necessary at all. But any person having sense of beauty will say to his tailor, please put frill to my frock. That way.
Here, which is the frill and which is the frock? Your lordships will have.
A number of circulars by the state government and central government, my lord, granting, because my lord, returns now by effects of time, returns are becoming bulkier and bulkier. There is definitely a chance, especially may not be for very big companies and all that, but if it is to be said that no, every individual has to file a return without any mistake, it is virtually impossible. There are bound to be mistakes, but bona fide mistakes. Some will not know what is the rate of tax. Some will not know what is the provision. Some may miss the provisions. There are bound to mistakes. Therefore, there are any number of circulars to say that if such mistake is pointed out, in fact, the assessing officer himself should rectify those mistakes and correct the compute the correct tax liability. So that is his duty.
There is one famous statement by Mahatma Gandhi ji. Freedom to err. Any freedom with no right to err is no freedom. The famous statement, which is P.A. Mahadev Desai used to quote very often. Freedom to err is the essence of freedom.
And most of the income tax return, a lot that may have seen the recent returns that are published by the central government. They run into 50, 60 pages. Even individuals, professionals will have to fill it unless you appoint some chartered accountant and do it. If you want to do
What
it,
is-
on your own, it's not.
What is the idea of error apparent on the face of the record? Judges do that error. Therefore, the appeal, review, revision, reference. Yes.
But, although the question of as if enacted is no longer central because we appear to be in some state of consensus. There's one judgment when I was going through it that I found interesting. Lordships may kindly come to the state of UP versus Delhi cloth mills.
Yeah, just I was thinking yesterday after hearing Surnarayana and you also. I was just thinking, I got up too early today. What is the effect of as if enacted in this act? It is subject to all ordinary norms of administrative law. Means it cannot transcend the Parent Act.
Yes,
It cannot transcend the constitutional provision,
yes,
and it continues to be a delegated legislation only.
yes, yes.
But efficacy level as such may be higher than that of other delegated legislation where such crowning is not done.
Precisely.
And
Precisely.
honest, I felt like
I
that.
bow down. I bow down.
How they have treated, how Apex Court has treated this.
Kindly come to para 15 by
Para 15, 1.5.
1.5. (77) of the Act is extracted. And then kindly see para 16. Both
So
the-
as if enacted.
Yes. Both the old and new Rule 814 must therefore have effect from the date of publication of the official gazette, or from such other date as may be specified in that behalf as if enacted in the Act. The object of this ancient formula, namely,
This is very ancient also.
namely, as if enacted in the Act, was to emphasize that the fact that the notifications were to be as effective as the Act itself. Its validity could be questioned in the same way as the validity of the Act could be questioned. It is an ancient form of rulemaking still to be found in the Act. Thus, the Act having provided for fixed wastage allowance, also in effect provided that the excess above the allowable wastage will be taxed. It cannot therefore be said that no such charging up of excise duty on the excess wastage in transit would be validly made. The validity of Rule 814 has not been questioned before the High Court. Then, my lord, I found the next line little bit illustrative. Absolute equality and justice is not attainable in taxing laws. Legislature must be left to decide the state policy within constitutional limitations.
This argument is in support of your contention that Rule 38 should be read as if it is part of 10, 11, 12, 13, 15, 18, up to 18, 19, like that.
Yes, my lords.
Prescribes any policy.
If it prescribes the policy, not form and other things.
Because that's what the Supreme Court says. Absolute equality and justice. This proposition cannot be denied. Nothing is well accepted proposition. Policy can be framed. There is no doubt about it.
That this is reading.
No, I
In a
understand what
given
my-
case, you may be put to injustice, but it is inevitable ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಹೇಳಿ. Of course, subject to that one.
Such condition, and if
Correct.
such condition is imposed, whether it is in line with the provisions of the act. Because my learned friend is also accepting that rules cannot go beyond the act. That proposition, my learned friend also fairly is not denying.
Yes.
The judgment of the division bench of the Madras High Court. I'll wait. That's, division bench of the Madras High Court, my lord, one of the judges, we also had the pleasure of appearing here in our court. And there is a judgment of his lordship when he was sitting single over here.
Yes.
The interesting and important question, I'm just reading the first para for a moment. Learned single judge stated so-and-so, allowing the writ petition of the assessee in writ petition number so-and-so, is as to the whether the assessee is entitled to utilize and set off the accumulated unutilized amount of education cess, secondary and higher education cess, and Krishi Kalyan cess, all jointly referred to as cess, against the output GST tax liability after the switchover of indirect taxation system to GST regime with effect from so-and-so, which GST levies subsumed within its fold 16 indirect taxes earlier leviable like excise duty, VAT, etc.
Yes.
The lordship may kindly come to para 54. Where JM is cited. I had cited JM at the outset, my lord, to show that input tax is a concession and conditions thereof have to be strictly complied with. The same bench of the your lordships have 54.
Yes, the same bench of the Honorable
Supreme Court, in a later case of JM and Co., in a case under the Tamil Nadu VAT Act, held that it is right law that whenever concession is given by a statute or notification, etc., conditions thereof are to be strictly complied with in order to avail such concession. Thus, it is not the right of the dealers to get benefit of input tax credit, but it is a concession granted by virtue of section 19. And therefore, the conditions for availing such input tax credit have to be fulfilled. Paragraph 11 to 13 of the said judgment authored by Honorable Justice so-and-so are quoted below for ready reference. Your Lordships may kindly come to 55, which is after 11 to 13 are extracted.
We are.
We are supported in our aforesaid view by the aforesaid two judgments, also largely because it is clear that SENVAT credit or input tax credit under the GST regime is a concession and a facility and not a vested right. Even if one were to rank such a right of SENVAT credit on the pedestal of a statutory right, even that right can be curtailed and regulated by conditions for availing such right. It is clear from the scheme of section 140 of the GST Act that the transition and carry forward of the input tax credit and taxes paid under the earlier indirect tax regimes were subject to conditions and specifications given in 140 of the Act, and unless specifically allowed, such carry forward or set off could not be claimed by any implied intention or so-called vested right theory. In our opinion, the unutilized education cess and secondary and higher education cess in the hands of the assessee had become dead SENVAT credit. But I have paid it. But legislature in its wisdom says there is only these methods or these conditions in which you can claim it. There is no unjust, it becomes dead. In the year 2015 itself, and therefore there is no question of it being claimed as a right to be carried forward and set off after July 1, 2017 against output GST liability. Finally, my lords, the scheme is discussed, and the order of the single judge is set aside. I am relying on this. I understand that the scheme of various statutes, like it may vary. It is of no avail to my learned friend to cite a 67 judgment under the Sales Tax Act. This judgment has its limitations, but vested right versus a concession is alive, my lord. And this is not a case where any constitutional validity was challenged. Not that it makes a difference to my mind. Photos.
Yes.
My lords, this is a short judgment, which is after leave is granted. Short point was whether I can, under the Income Tax Act, because some judgments under the Income Tax Act were cited to say even a letter is sufficient, etc., etc. The bench holds, my lords, that even under the Income Tax Act, the only way to claim any additional benefit is to file a revised return. Again, the scheme under the Act may be different, but the trend and the refusal of the court to look at exceptions is what I'm relying on, madam. Leave granted. The question raised in this appeal is relates to whether the appellant assessee could make a claim for deduction other than by filing a revised return. Assessment year in question was 95-96. Return was filed on 30/11/95 by the appellant for the assessment year in question. On 12/1/1998, the appellant sought to claim a deduction by way of a letter before the assessing officer. The deduction was allowed by the assessing officer on the ground that there was no provision under the Income Tax Act sorry, the deduction was disallowed by the assessing officer on the ground that there was no provision under the Income Tax Act to make amendment in the return of income by modifying an application at the assessment stage without revising the return. Appellant's appeal before the Commissioner of Income Tax, CIT appeals was allowed. However, the order of the further appeal of the department before the Income Tax Appellate Tribunal was allowed. The appellant has approached this court and has submitted that the tribunal was wrong in upholding the assessing officer's order. He has relied upon the decision of the court in NTPC versus CIT to contend that it was open for the assessee to raise points of law even before the appellate tribunal. The decision is question is that the power of the tribunal under section 254 of the Income Tax Act is to entertain for the first time a point of law provided the fact on the basis of which the issue of law can be raised before the tribunal. Decision does not in any way relate to the power of the assessing officer to entertain a claim for deduction otherwise than filing the revised return.
And by filing a
Revised return. In the circumstance of the case, we dismiss the civil appeal. However, we make it clear that the tribunal's power under 254 is not impinged. The reason, my lord, is yesterday's in the case of some DTA, some letter was shown to be in operation. I have just
Credit of tax and deduction, my other friend should, basic deduction is different from credit of tax. Wipro, which I cited, is tax credit which I have paid. Input tax is a tax credit, and tax paid in advance. Deduction cannot be equated with a tax credit.
Division bench of this court in Nandi disagrees, my lord. Division bench of this court in Nandi disagrees.
Different point, anyway, let my.
Correct. Correct.
both are same antana.
Everything. It is put on par, my lords.
Very far-reaching statements, but anyway, I'll deal with it when I'm dealing with this.
Your lordships may be kind enough to take the judgment that was cited by my learned friend of the Supreme Court, which 1999 7 SCC, Daichi Karkaria.
Daichi Karkaria judgment.
1999 7 SCC, it was cited by my learned friend.
ಇವ್ರದೆಲ್ಲ separate ಮಾಡ್ಕೊಡಿ.
ಫಸ್ಟ್ ಇರತ್ತೆ ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಮೊದಲನೇ ಡಿಸಿಷನ್ ಇರ್ಬೋದು.
ಫಸ್ಟ್ ಡಿಸಿಷನ್ ಹಿಚ್ಚಿ
1999 SCC ರಿಪೋರ್ಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈ ತರದ್ ನೋಡಿ, ಕಲೆಕ್ಟರ್ ಆಫ್ ಸೆಂಟ್ರಲ್ ಎಕ್ಸೈಸ್ ವರ್ಸಸ್ ತಗೊಳ್ಳಿ, ಕಂಪೇರ್ ಮಾಡಿ. Please put this in the other file.
Whether this Madras High Court was not carried in appeal to Supreme Court?
Pending an appeal.
In
In
appeal.
any case, Madras, I'll explain what Madras Sutherland issue is. My lord, when GST took
No,
over.
no, I'll hear you, I'll hear you.
Ah,
Just let
Just,
him
I
complete.
wanted to explain.
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಏನ್ರ ಕೊಟ್ಟಿದಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು? Stay.
In fact, we have petitions here on the same point.
On that point
Pay
also.
cases, whether pay cases and secondary cess which was paid under the VAT regime, service tax regime before GST came in. Whether
Can
that
be-
can be transitioned into GST. Because GST section 140 may not provide for the transitional provisions. The provision 140 said that whatever send-back credit, input tax credits you had in the earlier period, you can transition it. But 140 didn't speak of education cess and.
That was left, that was left over.
That was left over. So the SSCs filed writ petitions to contend that you have given us transition of the input tax credit.
This should also be given.
Given. That's the point in Sutherland.
In other words, tax which I have already paid, you cannot retain without giving me credit.
That's the policy. Section 140, by way of a provision, they decided not to give me.
Correct.
They have the argument in those cases of the central government and the state government is cess is not same as tax. cess was collected for the purpose of building roads and other things, it is not the same as tax. That's the argument that they have taken there.
Whether,
Therefore, I am
whether cess is also tax.
Cess is different, cess.
It depends upon the
tax
statute.
Statute. But the argument of the state and the central there is, if it was tax, we have given you transition, because they have given transition for the input tax credit. That's why, in fact, that goes to show that that is an indefeasible right, input tax credit, because that's tax paid in advance. How can they not give it? But they chose not to give credit for education and higher education cess.
When others were given, when other of the kind were given under the act itself.
Giving me credit for tax.
Why not for this?
Cess also, because virtually it is something that has gone out of my pocket. Whether what will happen now, the Supreme Court will have to decide on that point.
Yes.
Koti,
Collector of Central Excise versus Dai Aichi.
Your lordships may be kind enough to come to page 458.
Para 18.
No, my lords, it starts, the previous page, my lord, 457.
Para 17.
17. Where 57 capital A to rule 57 capital J are extracted. And some summarization is made. Then your lordships may, after 57F is extracted, your lordships may then come to what the court says. Rule 57 capital G provides that the manufacturer intending to take credit of duty paid on imports must file a declaration with the excise officer concerned, indicating what the final products are that are manufactured in the factory and the inputs intended to be used therein, and obtain an acknowledgement thereof. The manufacturer, having filed the declaration and obtained the acknowledgement, can take credit for the duty on the inputs received by him. Rule 57 capital I provides for the recovery of credit wrongly availed or utilized in an irregular manner. The manufacturer is then required to show cause as to why he should not be disallowed such credit, or if it has utilized it, why its value should not be recovered from him. After considering the reply, the excise officer concerned is empowered to make the appropriate order in such terms. It is clear from these rules, as we read them, that a manufacturer obtains credit for excise duty paid on raw material to be used by him in the production of an excisable product. Immediately, it makes the requisite declaration and obtains an acknowledgement thereof. It is entitled to use the credit at any time thereafter. Any time thereafter, when making payment of excise duty on the excisable product. There is no provision in the rules which provides for a reversal of the credit by excise authorities, except where it has been illegally or irregularly taken, in which event it stands cancelled or utilized, has to be paid for. We are really concerned with credit that has been validly taken, and its benefit is available to the manufacturer without any limitation in time or otherwise, unless the manufacturer itself chooses not to use the raw material in the excisable product. The credit is therefore indefeasible. My lords, he needs to jump through some hoops. Mere payment of money and sleeping on forms, declarations, acknowledgement, etc. does not make it indefeasible. You comply with my statute also, I will give you the credit, like I have done for what you have rightly claimed at 12.5%. It is not his case that I have denied input credit altogether. What he validly claimed, I have given him. What he forgot to claim, what he slept over, and this is what the Supreme Court says. Use of the word thereafter, use of the word validly taken. This is, I am not his accountant. Yes, here the rule provides for a return. Actually, the act provides for a return. I can read it again. Correct. This expression indefeasible, please, I am on my feet, please. This indefeasible, I am on my feet, please. This indefeasible right is waved like a flag everywhere without explaining the context.
I'll show.
Yes, yes, please wait.
What is meant by the last sentence
My lords.
at page 458? The credit is therefore indefeasible.
Right. After the expression validly taken, the expression thereafter, once he does all that, then it is indefeasible.
Yes.
The next, my lords, was a judgment of my lords Justice Kumar and Justice Malimat in the case of K bond polymers. I don't know for what this was cited, but my short submission in K bond polymers is, my lord, it is considered in centum, especially since my lord Justice Kumar was sitting on both the benches. It is considered in centum and distinguished.
Interpreted in centum.
Out of compare madak today. Centum ಕೊಟ್ಬಿಡಿ ಸಾಹೇಬ್ರಿಗೆ. ಇದು ಸಿಕ್ತಾ? Centum ಕೊಟ್ಬಿಡಿ. Centum ಬೇಕಾ ಕಂಪೇರ್ ಮಾಡಕ್ಕೆ? State of Karnataka versus Centum. 2015 77 VST. ತಗೊಳ್ಳಿ ನೋಡ್ಬಿಡಿ. ಇದು ಕಂಪೇರ್ ಮಾಡಕ್ಕೆ ಯೂಸ್ಫುಲ್ ಇರುತ್ತೆ, ನೋಡ್ಬಿಡಿ. Your lordships, in centum is straight away see.
Paras 1114.
Yes, my lord, but your lordship may kindly see 13, which is the judgment that was cited. And on both benches, my lord Justice Kumar was there. Reliance was placed on a judgment of this court in the case of State of Karnataka versus K bond polymers, where this court was dealing with subsection 3 of section 30 of the act and held that once tax is paid under the act, the assessee is entitled to benefit of input tax. Delay in putting forth the claim for refund did not in any way affect his right to claim that was the said amount, which was legitimately due to him under the act. That was a judgment rendered in connection with claim of refund. It dealt with credit and debit notes. It has no application to a case of setting off input tax against output tax under section 10 of the act.
So to this case, it is not relatable at all. That is bond Messrs. K bond.
K bond polymers, which was cited across the bar. My submission is it was considered by the division bench while arising centum, and division bench holds that it is no application. Your lordships may.
Yes.
There was a judgment of learned single judge of this court. My lords, which I will, for the time being, not trouble your lordships with, it's a single judge. The discussion that happens in Bharat Earth Movers, my lord. STRP 234 of 2016, where this decision of the single judge is
Commented upon.
commented upon. It was not before it.
ಯಾವ್ದು ಕೊಟ್ಟಾರೆ?
Sorry, Vineet Kothari.
The batch usually BM. Kirloskar and Sonal occurrence, it was a batch, leading matter was BM.
Okay.
Kirloskar and Sonal occurrence were part of the entire batch.
I stand correct, no problem,
Yes.
no problem. Your lordships have,
Para 31 we read in that one.
yes,
We have made note in 31.
31. Your lordships may kindly see what happens here. The facts are extracted.
31 and 32.
My lords.
Yes. Daichi Karkaria.
Which I have made my submission on. Where, what is the context for indefeasible right? I have made my submission. And that was waived before the court in this. Now, your lordships may see, there is extraction.
ಯಾಕೆ ಇಷ್ಟೊಂದು discordance between the judgments?
I'll explain.
Huh?
I'll explain. The facts are different.
Okay.
I'll explain.
Okay.
Why I'll give all the judgments against which the development has relied. I'll show the judgments in favor which discusses those judgments. I'll explain. The facts are very different.
Yes.
Because Malords will find the very same bench taking two different views in many cases. Justice Kumar and K. Bond has said this, Justice Kumar and K. Bond has said something else. Justice Jayant Patel in the foundation cited by Manan yesterday said one thing. In Jones.
No, that's exactly contrary.
Justice Vineet Saran has taken one view in Mandi. He's taken a contra view. I would say contra view. On facts, he's taken a different view in Manyata. I'll explain all.
Manyata, my lord.
Everything depends on the ratio of the gestation. I mean, basic principle. The ratio.
In the
of
facts
gestation has to
matrix
be
of that
derived
case.
Facts that were there before the.
Yes. ಆದ್ರೂ ಇಂಥ ಪ್ರಪೋಸಿಷನ್ಸ್ ಮೇಲೆ ಸ್ವಲ್ಪ ಜಡ್ಜಸ್ ಕೇರ್ಫುಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬೇಕು. ಅದರ್ವೈಸ್
And in fact,
ಅದು ಅಸೆಸ್ಸಿಗೆ ಅಫೆಕ್ಟ್ ಆಗ್ಬೋದು, ಸ್ಟೇಟ್ ಎಕ್ಸ್ಚೆಕರಿಗೆ ಅಫೆಕ್ಟ್ ಆಗ್ಬೋದು.
tax matters especially, my lord yesterday rightly said, any view taken by your lordship will affect.
Yes.
Cost.
ಅದು ಬೇರೆ ಬೇರೆ ಸಮಸ್ಯೆ ಆಗ್ತದೆ.
Very careful. And in fact, my lord, it's a duty on the, I mean, my learned friend also has been citing many judgments. It's a learning experience for, not just for your lordship, but for us also. But the point is, and your lordships.
But we learnt a lot from both of you.
And your lordship gracefully said, you will hear everything. If you
Yes.
give,
ಒಂದು ಸರಿ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆಗಿ ಏನ್ ಹಿಂಗ್ ಯಾಕೆ ಆಗ್ತಾ ಇದೆ ಅಂತ.
What is this? In one SSC case, the havoc and chaos symptom has caused. Alerts on ground, we are not people handling matters on ground, dealing with assessing officers. Poor SSCs, people who have not filed returns, not claimed input tax credit by a mistake and all that have suffered so much. In fact, one decision of this honorable court following sentence, in fact, had to be stayed by the Supreme Court also. I'll point out, I thought my learned friend will rely on the decision.
The MFAR.
Stayed by the Supreme Court as well. So it has far-reaching consequences.
I can cite MFAR, my lord. Since it's been stayed, I did not rely on it. I can cite MFAR. The articulation in MFAR by both the single judge as well as the division bench, my lord, according to me, is crystal clear.
They relied on sentence that's been stayed by the Supreme
Even
Court.
the
I'm just-
other judgment of, I will not name the judges in that, where they say it is a right, it is a license, interest is created. Next paragraph, interest is not created.
There is some this thing. In fact, that's why, my lord, I was yesterday, I said it's a learning experience because I was reading on the principles of doctrines of sub silentio, per incurium, and there's something called per ignoratium also.
Correct.
If it's not been brought to the notice of the
Notice of-
judges, in centum ideally, Giridhari Parasmal and earlier decisions of this honorable court, and the Supreme Court taking the view that a valid claim, if given by the act, has to be made, can be made before the assessing authority. Assessing authority has a duty to compute the correct tax liability. All that was not
Argued at all.
brought to the notice of the court. It there, the Supreme Court says it is not per imperium, it is per ignoratium.
It, the English judges called it the judgment sub silentio.
Subside.
But I think Supreme Court said with reference to certain facts or mixed questions of law and facts. In sub silentio, they will not adhere to provision of law at all. That is sub silentio. This is a per ignorantia. It can happen. But this is per confusio. Yes, the confusion. Tax principles. In fact, in Raghuvamsha by Kalidasa, he says how taxation should be done. ಅವನು ಹೆಂಗೆ ಹೇಳ್ತಾನೆ ಅಂದ್ರೆ ಬಹಳ ಚೆನ್ನಾಗಿ ಹೇಳ್ತಾನೆ. ರಾಜ ತನ್ನ ಪ್ರಜೆಗಳಿಂದ ಟ್ಯಾಕ್ಸ್ ಅನ್ನ ಯಾವ ರೀತಿ ತಗೋಬೇಕು ಅಂದ್ರೆ ದುಂಬಿ ಹೂವುಗಳಿಂದ ಹೇಗೆ ಮಕರಂದವನ್ನ ಹಿರತ್ತಲ್ಲ, ಆ ಹೂವನ್ನು ಡ್ಯಾಮೇಜ್ ಮಾಡ್ದಂಗೆ ಸೂಕ್ಷ್ಮವಾಗಿ ಮಕರಂದವನ್ನ ತಗೊಂಡು ಅದು ವಿತ್ ಗ್ರಾಟಿಟ್ಯೂಡ್ ಇಟ್ ರಿಟರ್ನ್ಸ್, ಇಟ್ ಫ್ಲೈಸ್ ಬ್ಯಾಕ್ ಟು ಅದರ್ ಫ್ಲವರ್. ಆ ರೀತಿ ಇರಬೇಕು ಅಂತ ಹೇಳ್ತಾನೆ ರಘುವಂಶದಲ್ಲಿ. ಎರಡನೇದು, ರಾಜ ಕರ ವಸೂಲಿಯನ್ನ ತತ್ವಗಳನ್ನು ಆಧರಿಸಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಇಟ್ ಶುಡ್ ಬಿ ನಾರ್ಮೇಟಿವ್ ಅಂತ ಪುಸ್ತಕ ನೋಡಿ, ಕಾಳಿದಾಸ ಬರೆದಿದ್ದು. ಒನ್ ಹೂ ವಾಸ್ ಗ್ರೇಜಿಂಗ್ ದಿ ಶೀಪ್, ಹಿ ರೈಟ್ಸ್ ದೀಸ್ ಬುಕ್ಸ್. ಎಂತೆಂಥ ಪುಸ್ತಕ, ಏನು ಇದು ಅಭಿಜ್ಞಾನ ಶಾಕುಂತಲ, ರಘುವಂಶ, ಎಂತೆಂಥ ಪುಸ್ತಕಗಳು, ಮಹಾನ್. ಎಸ್
My lords, the judgment in BML, in considering it was a batch matter, I was not there. My lords, there is narration of the facts leading up. Then the assessing officer's order is extracted in para 8.
ಚಂದ ಬಂದಿಲ್ಲ ಈ ಜಡ್ಜ್ಮೆಂಟ್. ಎರಡು ಸರಿ ಓದ್ದೆ ನಾನು.
Then
ಚಂದ ಬರಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು. ಎನಿವೆ, ಇಟ್ ಶುಡ್ ನಾಟ್ ಮೇಕ್ ದಟ್.
10,
ಎನಿವೆ, sometimes
10, the submissions are,
Difficult may not be as lawyers to make our submission.
ಕರೆಕ್ಟ್. ನಾವು ಹೆಂಗ್ ಬರಿತೀವಿ ನನ್ನ ಮೇಲೆ ಅದು ಒಂದ್ ಕಡೆ ವಾಟ್ ಯು ಸೇಡ್ ಇಸ್ ಟ್ರೂ. ಅದು ಯಾವುದೋ ಒಬ್ಬ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಲಾ ರಿಪೋರ್ಟರ್ ಕರೆದು, ಇಟ್ಸ್ ಎ ಫ್ಯಾಕ್ಟ್, ಏನು ನಿಂದು ಲಾ ರಿಪೋರ್ಟಿಂಗ್ ಇದು ಎಲ್ಲ ರಿಪೋರ್ಟ್ ILR ಕ್ವಾಲಿಟಿನೇ ಇಲ್ಲ ಅಂತ ಎಲ್ಲರೂ ಬೈತಾ ಇದ್ದಾರೆ, ಏನಿದು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಅಂತ. ಅವ್ರು ಹೇಳಿದ್ರು, ನಾನು ಲಾ ರಿಪೋರ್ಟರು, ಕ್ವಾಲಿಟಿ ಆಫ್ ದಿ ಜಜ್ಮೆಂಟ್ ನಿಮ್ ಕೈಯಲ್ಲಿದೆ, ನಾನೇನ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ. ನೀವೆಂತ ಜಜ್ಮೆಂಟ್ ಬರೀತೀರಿ, ಅವ್ನು ರಿಪೋರ್ಟ್ ಮಾಡ್ತೇನೆ ನಾನು. ನೀ ಚಲೋ ಜಜ್ಮೆಂಟ್ ಬರೀರಿ, ಅವ್ನು ರಿಪೋರ್ಟ್ ಮಾಡ್ತೀನಿ. ಚೀಫ್ ಜಸ್ಟಿಸ್ ಡಿಡ್ ನಾಟ್ utter one single word.
Here, as my brother, 1967, so just 3 paragraphs.
ಏನ್ ನೋಡಿ ಎಷ್ಟು ಬ್ಯೂಟಿಫುಲ್.
See the ratio that's come
ಅದೇ
out.
ಅದೇ ರೀತಿ ಇಂಗ್ಲಿಷ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಕ್ಸ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ರಿಪೋರ್ಟ್ಸ್ ಅಂತ. ಕಾಕ್ಸ್ ಅವನ್ನ ಮಾಡ್ದ ಒಂದು 8 ವರ್ಷ ಏನೋ ಇದ್ದ ಅವನು. ಆ 8 ವರ್ಷದಲ್ಲಿ ನಾವು ಕಾಕ್ಸ್ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ರಿಪೋರ್ಟ್ಸ್ ಅಂತ ಮಾಡಿದಾನೆ. 1 ಪೇಜು 1.5 ಪೇಜ್. ಕನ್ಫ್ಯೂಷನ್ ಸ್ಕೋಪೇ ಇಲ್ಲ. ಈ ನಮನಿ ರೈಟ್ ಈಸ್ ಇಂಡಿಫೀಸಿಬಲ್, ನಾಟ್ ಎ ಡಿಫೀಸಿಬಲ್, ಈ ಕನ್ಫ್ಯೂಷನ್ನೇ ಇಲ್ಲ. ಕ್ಲಿಯರ್ ಕಟ್. ಅದನ್ನ ಓದಿಬಿಟ್ರೆ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಓದ್ದೆ. ನಾರಾಯಣ್ ಪೈಗೆ ಹೆಂಗಿದೆ ನೋಡಿ ಜಡ್ಜ್ಮೆಂಟ್, ಎಷ್ಟು ಚಂದ ಬರ್. ಸುಮ್ಮನೆ ನಾವು ಉದ್ದಕ್ಕೆ 20 ಪೇಜ್ ಬರೆದು ವಿ ಆಡ್ ಮೋರ್ ಕನ್ಫ್ಯೂಷನ್ ಟು ದಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಆಲ್ರೆಡಿ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಸಮಸ್ಯೆ ಆಗ್ತದೆ, ನಾವು ಟ್ಯಾಕ್ಸ್ ಡೊಮೇನ್ ನಿಂದ ಬಂದಿಲ್ಲಲ್ಲ, ಸೊ ವಿ ಹ್ಯಾವ್ ಡಿಫಿಕಲ್ಟಿ. ನಾನಾಯ್ತು, ನನ್ನ ಬ್ರದರ್ ಆಯ್ತು, ಇಬ್ರು ಟ್ಯಾಕ್ಸ್ ಡೊಮೇನ್ ನಿಂದ ಬಂದಿಲ್ಲ. ಅಟ್ ಲೀಸ್ಟ್ ನಾನು ಇಂಕೂ ಬಂದಿಲ್ಲ ಟ್ಯಾಕ್ಸ್ ಡೊಮೇನ್ ನಿಂದ.
Unless you have practiced at ground level, but the way you look at things, even my lord, the difficulty is there for the SSCs and the revenue, whichever council is arguing. If you don't see the actual realities of how a return is filed, the practical way of.
ಅವ ಪೂರ್ಣ ತಿಳಿಯುವುದೇ ಇಲ್ಲ ಕಾನೂನು.
Then you don't know how to, you will not.
ಥೆರಟಿಕಲ್ ಆಗಿಬಿಡ್ತದೆ, ಪ್ರಾಕ್ಟಿಕಲಿ ಏನ್ ಜಸ್ಟಿಸ್ ಆಗ್ಬೇಕು ಅದಾಗೋದೇ ಇಲ್ಲ. Yes.
I will go so far as to say, my lord, up to paragraph.
ಇಷ್ಟು ವರ್ಷ ಆಯ್ತಲ್ಲ, ನಿಮ್ ಗೌರ್ಮೆಂಟ್ ಏನಾಗಿದೆ? ನಿಮ್ ಗೌರ್ಮೆಂಟಿಗೆ ಒಂದು ರೂಲ್ ಅಮೆಂಡ್ ಮಾಡಕ್ ಬರಲ್ವಾ? ಇಟ್ ಇಸ್ ದ ಗೌರ್ಮೆಂಟ್ ವಿಚ್ ವಿಲ್ ಅಮೆಂಡ್ ದ ರೂಲ್. ಬರ್ದು unless input tax credit is claimed in the return itself, the claim shall not be allowed.
Kindly see
ಒಂದು
section,
ಸೆಂಟೆನ್ಸ್ ಬರೆಯಕ್ ಬರಲ್ವಾ?
kindly see section 10.6.
ಇಷ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ದಾಗ ಮತ್ತೆ ಲೆಜಿಸ್ಲೇಚರ್ ಬೇಕಿಲ್ಲ. ಆಸ್ ಇಫ್ ಇನ್ಆಕ್ಟೆಡ್ ಇರೋದಕ್ಕೆ ಗೌರ್ಮೆಂಟ್ ಕ್ಯಾನ್ ಡೂ ಇಟ್ ವಿದಿನ್ 24 hours.
Here they make finance act and most judgments are overturned in the finance act. Not only this budget, February, they have overruled Supreme Court judgment and shall retain hand by amending the provisions. I won't say overruled, but got over those judgments.
Kindly see 10.6, my lords.
By what income tax amendments. we
Keep
have-
on happening. ಇದು ಸ್ವಲ್ಪ ಪ್ಯಾರಾಗ್ರಾಫ್.
This judgment I'll conclude before going to 10.6. Your lordships have raised the question. My lords, here, my respectful submission, my lords, is up till paragraph 30, there is nothing but extraction and summarization of facts, assessing order, previous judgments, etc., etc. 31 starts with, thus in view of the above recorded findings. Whose findings? We respectfully agree with the opinion of the Honorable Single Judge. Law laid down in Collector of Central Excise versus so-and-so has been time and again followed by Honorable Supreme Court in several cases. It is settled that input tax credit is an indefeasible right. On Supreme Court's judgment, my lords, I have made my submission that it is in the context of that paragraph, it has to be read. And then, my lord, without any attempt to distinguish what the other benches have heard and decided, a departure is recorded. It is a judgment of the division bench. There is no shying away from that. But what am I to meet over here? What am I to meet over here? Other than the summarization, there is nothing for me to meet over here. Your lordships had raised a question on
In learning the law by Glanville Williams, he says while deciding the weight of the decision, you should see the stature of the judge who wrote that judgment.
my lords,
How to decide that? ಅಲ್ಲಿದೆ
my lords.
weight of the decision ನೀವು ಅಸೆಸ್ ಮಾಡುವಾಗ the stature of the judge should be looked into ಅಂತ ಬರ್ದಾನು. At least Surya, at least I will do that.
My
Then immediately we can know what is the quality of
my
the judgment.
my limited experience is that each appellate judge in the country also does that.
We see the names.
Cyberಗೆ act ಕೊಡಿ. VAT Act, Karnataka VAT Act.
But yes, it's here.
So what is the ಯಾವ year ಇದೆ?
ಇದು 2004, Act number 2004. ನೀವು ಓಲ್ಡ್ ಆಕ್ಟ್ ಬೇಕು ಅಂತ
Edition
ಹೇಳಿದ್ರಲ್ಲ,
ಇಲ್ಲ
ಹೊಸ ಆಕ್ಟಾ?
what's that?
ಹೊಸ ಆಕ್ಟ್ ಮತ್ತೆ ಸೂರ್ಯನಾರಾಯಣ 2015-16
ಇರ್ಬೋದು.
ಇದೆಯಾ ಪೇಜ್ ನಂಬರ್?
Your lordships may come to 10.6.
ನಾವೇನೋ ಸ್ವಲ್ಪ ಹ್ಯೂಮರ್ ಇರ್ಲಿ ಅನ್ನೋದಕ್ಕೆ ಇಷ್ಟೆಲ್ಲ ಮಾತಾಡಿದ್ವಿ ಅನ್ನೋದು ಬಿಟ್ರೆ, we have got great respect for all judges For all judges who have granted respect.
Your Lordship, sir, 10-6.
10-4,
10-6, sir.
10-6. 10-6
That may be pre-amendment.
5 ಗೆ ಮುಗ್ದೇ ಹೋಗಿದೆ.
ಹಾ.
ಓದ್ಬಿಡಿ ಒಂದ್ಸರಿ.
10-6.
ಇದು ಪ್ರೀ ಅಮೆಂಡ್ಮೆಂಟ್ ನಿಮ್ದು.
This is inserted by Act 6 of 2016. You have the amendment Act 6 of 2016. Notwithstanding anything contained in the Act, input tax deducted by a registered dealer to calculate net tax payable is provisional to a dealer who fails to furnish or furnishes incorrect and incomplete particular for preparation of the return in the prescribed form electronically through internet in the manner provided in the notification issued by Commissioner under first proviso to Section 35, and the jurisdictional local VAT officer or VAT sub-officer shall assess such dealer for such tax period by disallowing input tax claimed by him and issue demand notice. 2016, this story has come to an end.
ಏನಂತ ಹೇಳ್ತದೆ ಅದು?
Notwithstanding anything contained in this Act, input tax deducted by a registered dealer.
In this act means it includes the rules also.
Deducted by a registered dealer to calculate net tax payable is provisional to a dealer who fails to or furnishes incorrect, who fails to furnish or furnishes incorrect and incomplete particulars for preparation of the return in the prescribed form electronically through internet in the manner specified in the notification issued by Commissioner under first proviso to Section 35, and the local VAT officer or VAT sub-officer shall assess such dealer for such tax period by disallowing input tax claimed by him and issue demand notice.
What does it say according to you?
If the return is not filed,
Correctly.
he fails to furnish or furnishes incorrect and incomplete particulars, the officer is required to disallow the input tax credit, which is nothing but an implementation of infinite builders and centum. Contrary to the submission that legislature diluted it, in 2016, the legislature has implemented it. Infinite, my Lord Justice Shailendra Kumar's judgment started with that. And legislature has implemented. I will pass a copy, my Lord, of 10-6, 10 after amendment. Because your Lordship's asked rule yak hakilla, amend yak madilla. I've cast a mandate in keeping in mind centum, keeping in mind infinite builders. Nodi adarna disallow madbeku neevu, because Honorable High Court says so. Then this
ಇಲ್ಲಿರುವಂತ ಡಿಸ್ಪ್ಯೂಟು ಬರೀ ರೇಟ್ ಆಫ್ ಟ್ಯಾಕ್ಸ್ ಬಗ್ಗೆ ಮಾತ್ರ ಇದೆನಾ? Not whether you claimed it in your return or not is not the question.
he failed to claim it.
Difference
The
between
rate difference
that
ಏನಿದೆ?
4% and 2%, what section?
ಅಲ್ಲ, we'll understand the facts, basic facts first. In your returns,
Yes,
you have claimed input ITC,
yes.
you have claimed. But at the rate of tax mention ಮಾಡುವಾಗ wrong rate of tax.
ಇಲ್ಲ, ಇಲ್ಲ. I'll explain. My lord, input tax credit basically comes out of my purchases.
Correct.
Now purchases can be different goods which are subject to different rates. When I purchase, there may be goods I purchase at 12.5% rate.
5% ಇರ್ಬೋದು, 12 ಇರ್ಬೋದು, 8 ಇರ್ಬೋದು.
4% and 12.5%
Whichever.
at the relevant time.
Okay.
Subsection, section 11.5A, read with section 14 says, 11A5, 11.5, whatever, basically says that if I am stock transferring my goods after purchase of these, I have claimed input tax credit, I have paid 12.5% or 4% on this thing. And if I want to take credit and I am stock transferring the goods manufactured out of that or the same goods to another branch, outside of the state, then my input tax will be subject to section 14. Section 14 said that any tax above 4% or as notified, more than 4% or as notified, you cannot claim. You can claim. You can claim. So what I did is from 12.5%, I have reduced the 4% and claimed the 8.5%. On goods which I purchased at 4%, I thought because the section says 4%, I cannot claim it at all. But I didn't realize that there were two notifications that were issued reducing that 4% to 3% and 2%. That was the mistake I made. I didn't realize that those notifications were there. When I realized that those notifications were there, reducing the 4% to 3%, obviously, since I have paid 4%, that 1% and 2% I have to claim, which I did not claim it in the return.
ನಿಮ್ಮ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು ಎಲ್ಲಿ ಸ್ಟೇಟ್ ಈ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನು ಎಲ್ಲಿ ಸ್ಟೇಟ್ ಮಾಡಿದೆ?
Tribunal ನಲ್ಲಿ ಬಂದಿದೆ. Tribunal order ನಲ್ಲಿ which I read.
ಅದೊಂದು ಸ್ವಲ್ಪ ತೋರಿಸಿ, ಪೇಜ್ ತೋರಿಸಿ.
Order of the tribunal, if my lords have.
Then it boils down to only rate of tax alone.
I have filed the return. I have otherwise claimed input tax credit. Only on this differential, I did not claim the.
Which paragraph of the impugned order?
Impugned order starts at page
19,
Running
effective
page
order
19.
it begins.
running page 19.
Ah.
And my lords will get the facts at para 40, page 43. Running page 43, para 40, or internal page 26. Out in the instant case.
It can be gathered from the.
It can be
argument.
gathered from the arguments of the learned counsel and from the records for the period in question, the appellant has filed monthly return of turnover in form VAT 100. Further, inter alia, the appellant, while calculating its net tax liability under the act, has claimed input tax credit on purchase of inputs chargeable to VAT at 12.5% on the manufacture of stock transferred goods at a rate higher than 2% with effect from 1/4/2008 as per the provisions of 11A5 and section 14. Read with notification number so and so and notification number so and so and notification number so and so.
In other
In
words,
other words, the appellant has availed input tax credit to the extent of 10.5% of the local purchases and inputs chargeable to VAT at the rate of 12.5% utilized in the manufacture of stock transfer goods. However, it was further noticed by the bench that the appellant in an inadvertent manner and in a bona fide belief that the aforesaid benefit of entitlement to avail input tax credit on goods used as inputs in the manufacture of stock was only available in respect of goods liable to tax at the rate of 12.5% and not available in respect of inputs purchased, transferred at the rate of 4% utilized in the manufacture of stock transfers good, has not claimed the benefit of input tax at the rate of 1%, that is 4% minus
3%.
during
The
those,
monthly return
during
of-
April and May. And 43 says, because 40, again in May, they reduced the rate from 3% to 2% by a notification. Also, the appellant has not claimed the benefit of input tax at 2%, 4% minus 2% in the monthly return for turnover for the tax periods June to March. So first 2 months, I did not claim that additional 1% benefit I got. And the remaining 10 months, I did not claim the additional 2%. In other words, the appellant for the period from so-and-so has not availed input tax credit to the extent of 1% on the local purchase of so-and-so at the rate of 4%. Also, in other words, for the period June 2008 to March 2009 has not availed input tax credit to the extent of 2%. It can very well be seen that the appellant was unaware of the above mistake committed inadvertently by him, and on the pretext that there was no mistakes committed in filing the original monthly returns for the period, has not filed revised returns for the aforesaid periods in question. At this juncture, bench would like to infer upon the fact that when an assessment under section
All right.
38(1) is used.
ಏನು ಎಷ್ಟು ಕಾಂಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ ಹೇಳಿಕ್ ಬರ್ತಿತ್ತು.
ಹೌದು. No, they repeated more, a lot of repetition is.
Yes.
Scheme, my lord, is
ನೀವನ್ನೋದು ಈ ಮಿಸ್ಟೇಕ್ ಇದೆಯಲ್ಲ, ಇಟ್ ಈಸ್ ಆಸ್ ಗುಡ್ ಆಸ್ ನಾಟ್ ಫೈಲಿಂಗ್ ದ ರಿಟರ್ನ್ ಎಟ್ ಆಲ್ ಅಂತ ನಿಮ್
No, no
contention.
return is filed. Your lordships may kindly see how this arises. Your lordships may kindly take.
But authorities will be knowing what is the rate. Suppose because the duty of the state is not to levy more than what is legally permissible. Just discussion.
My lords.
There are many points which you
My
have
lord.
argued which require due weightage is another thing. Suppose ರಿಟರ್ನ್ ಹಾಕಿಲ್ಲ ಅವ್ನು. ಅಂದ್ರೆ ಆ ಕಾಲಮ್ ಅನ್ನು ಬ್ಲಾಂಕೆ ಬಿಟ್ಬಿಟ್ಟಾನೆ ಫಾರ್ಮ್ 100 ನಲ್ಲಿ. He has kept that column blank. That is one extreme case. He has not kept the column blank. He has claimed input tax concession, but at a rate what was not correctly reflected in law, prescribed by law. ಆ ಹೊತ್ತಿನಲ್ಲಿ ನೋಡಪ್ಪ, ನೀನು ಕಡಿಮೆ ಕೇಳಿದೀಯಾ, ನಿಂಗೆ ಇನ್ನೂ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕ್ಲೇಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಲಾದಲ್ಲಿ ಹಂಗಿದೆ ಅಂತ ಅಥಾರಿಟೀಸೇ ಮಾಡಬೇಕು, ಅಥವಾ ಬಿಕಾಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಸತ್ಯನಾರಾಯಣ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಯು ಹ್ಯಾವ್ ರೆಡ್, ಇಫ್ ಇಟ್ ಈಸ್ ಬೆನಿಫಿಷಿಯಲ್ ಟು ದ ಸ್ಟೇಟ್ ವಿ ವಿಲ್ ಡೂ ಇಟ್, ಇಫ್ ಇಟ್ ಈಸ್ prejudicial to the state we will not do it ಅನ್ನೋದು ನಿಮ್ಮ ಆನ್ಸರ್.
One more aspect, my lord, is how it is structured. 11, your lordships may take 11 of the act,
11 of
VAT Act, VAT.
yes,
Input tax restrictions. Input tax shall not be deducted in calculating the net tax payable. 10 says net tax is output tax minus input tax. 11 clarifies that with respect to 11A clarifies that with respect to the following items, input tax is not deductible. Except comes in 14.
that comes in 14. So 14 is an exception to 11.
14 is an exception. Only to 11A, 5 and 6 to the extent provided in 14.
Eleven is the restriction, 14 is the exception to the restriction.
Restriction. One second, ನೋಡಿ ಇನ್ನೊಂದ್ಸರಿ ಓದಿ.
Manage.
Input tax shall not be deducted in calculating the net tax payable in respect of tax paid on purchases attributable to sale or manufacture so and so of exempted goods. ಇದೇನು ಅಪ್ಲೈ ಆಗಲ್ಲ ನಿಮಗೆ.
5 and 6. 6 ಬರಲ್ಲ.
Tax paid on purchase of goods that are dispatched outside the state or used as inputs in the manufacture, processing or packing of other taxable goods dispatched to a place outside the state, other than as a direct result of sale or purchase in the course of interstate trade or commerce, except as provided in section 14. You admit that it fits into section 14.
It fits into section.
Obviously.
That I have not discussed.
This one. Your only contention is because of this jungle of precedents. Your contention is that whatever he has claimed, that alone is our focal point. Right and wrong is not the factor. And that right and wrong, if at all you want to address,
In your
you have to
revised.
file the revised return, and that has to be done within the limitation period.
Very
This is your
Very much. Otherwise, my lord, yesterday I cited a judgment of the Supreme Court. Administrative inefficiency, my lord. If a burden is cast upon me to say in ಏನ್ ಸ್ವಲ್ಪ ಕೊಡ್ಬೋದು ಅಂತ, it is if the
But constitutional prohibition, article 265 ಯಾವುದು? 265.
without authority.
Without authority of law, you are not supposed to levy tax at all. Retaining input tax, is it not unauthorized on the part of the state?
Not.
Not.
Not at all. It is a concession.
Therefore, you are saying it's a concession.
It's a concession. It's a concession. He does not know how to avail it. I cannot help him. A concession is availed only in the manner provided around the concession. Lords, after the submission on BEMEL, again, matter travels to the Supreme Court. I am not troubling your lordships with the Supreme Court judgment, except to say that there is no law laid down by the Supreme Court. If there is any contest on that proposition, I'll read Kunaimat, but otherwise, I think. Because some submission was made that it has the stamp of approval. I'll just make a limited submission on that. ಅದು Supreme Court single page order ಇರುತ್ತೆ, ಅದು ಕೊಟ್ಬಿಡಿ ಸಾಹೇಬ್ರಿಗೆ. You have Kunaimat, you want?
Sorry?
Kunaimat, you want?
Kept open to be agitated ಇದೆಲ್ಲ ಇತ್ತು.
Left open that we have discussed.
Yes.
That Gujarat
Yes.
High Court.
Pune Ahmad also, but settled.
Settled. Sent. Fair enough. Fair enough.
Selfie simply dismissed, civil appeal dismissed.
ಇದು ಇದ್ರ ಮೇಲೆನೆ ಈ ದಿನೇಶ್ ಕುಮಾರ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆನೆ.
Went. Ali, Supreme Court says, though there is huge delay of 266 days in filing the special leave petition, we have nevertheless heard learned AAG appearing for the state of Karnataka on the merits of the case. Having heard learned AAG on the merits of the case, we find in the facts and circumstances of the present case, and particularly having regard to the nature of the transactions involved, we are not inclined to interfere in the matter. Special leave petition is hence dismissed. Since we are dismissing the special leave petition on merits of this case, we find in the interest of justice, the delay is also condoned. It is needless to observe that having regard to the aforesaid order and disinclination to interfere in the matter, question of law, if any, which arises, is kept open to be agitated in any other appropriate case. Lords, the short submission is
ಅಲ್ಲ ಕೆಪ್ಟ್ ಓಪನ್ ಅಂದ್ರೆ
by the Supreme.
by the apex court.
By the-
But law declared, if at all something is declared, it remains. In case it is not, no law is declared,
contention.
nothing contention.
The expression dismissed on merits does not lead to any declaration of law.
ಅಲ್ಲ ಅದ್ ಬಿಡಿ. That's all.
That's
That's all.
Para 40, para 40.
Even he also said that.
Then I'll not bother with coded distilleries also. That's 67 Karnataka.
Narayan Pai
Narayan.
judgment.
My Lord Justice Narayan Pai's and Justice Venkateswamy's judgment was under the old act. And my respectful submission is that the ratio laid down in India agencies, which says, Justice Lakshmanan's judgment, that there may be some inconvenience even to an honest dealer. But the mechanism provided for in the statute has to be complied with to promote administrative efficiency as well as to prevent fraud on the state. My Lord Justice Ravindran's judgment is also under the old act. Income tax, I've made my submissions. My Lords, in the assessee's own case, respectfully, my Lord, again, there is no discussion on 35-38. Corporation Bank, my Lord, 2009 Supreme Court. Your Lordships may see Corporation Bank versus Saraswati Abharan Shala, some gold case.
I've cited.
Yeah,
You are citing.
no, I'm just, I'm attempting to distinguish it.
Oh, I have cited.
Taos automatically.
Para 2024.
Yes. Here, my lord,
Case of refund,
but kindly see 23.
23.
The amendment reducing the rate of tax was given a retrospective effect by the state. It is in that circumstance, my lord, where I say that the rate of tax, which is in my sole prerogative, even the court cannot tell me reduce the rate of tax. I say retrospectively, ನಾನು ಕಡಿಮೆ ಮಾಡ್ಬಿಡ್ತೀನಿ. Why would I not give it back? Give it.
When you are doing it with retrospective effect, obviously that would happen.
Obviously. It is in that circumstance that this judgment is rendered.
But that is an additional reason. Para 23. See, for a judgment, plural, there may be plurality of reasons.
Yes.
If it's an additional reason, and if that reason is removed, even then the ratio would remain intact. This Professor Leslie Wambach's test, which Salmon refers to. If a case is decided on X proposition, and Y proposition is an additional proposition, and if Y is removed, the output of the decision would remain intact. Then X itself is the ratio decidendi. Professor Wambach.
The invocation of 265, when I have removed the charge retrospectively, nothing attaches to it. But when I'm saying there is 265 says I can neither levy nor collect without authority of law.
Correct.
I'm saying I neither want to levy nor collect it.
No, retaining what you could not have levied because it is paid by the citizen.
Correct.
The Supreme Court say is impermissible.
Very well noted. In the case of a tax, as distinguished from on the tax, a benefit or concession that I give in addition. That distinction has to come. Which is to say, under the charging section, under section 4, if I say that, look, going back to 2005, or when the statute came into force, I am now reducing all VAT to 4%. Your lordships will say, you have chosen to do that, you return it. That affects the levy of tax and the rate at which it is charged. As opposed to, there is no dispute as to the rate on which tax is payable. Certain deductions which I have permitted, circumscribed by the manner in which, form and manner in which they have to be claimed. Somebody fails to do so, that does not rise to the level of a vested right, to which 265 is attracted. The entire, my lord, distinguish after he complies with it, and that is what Daiichi says. Once he complies with everything that I have told him in order to claim that benefit, yes, it begins to rise. Thereafter, having complied with the act, it rises to that level and 265 may come in. Up until that level, it does not rise to the level, my lord, is my submission.
This aspect was not considered in Moffat law. Right to refund should be.
Context. Refund of central excise, which has been passed on. Whether
That is a doctrine of
unjust enrichment and what is the method of claiming it, because the SSC is there invoked section 72 of the Contract Act and says you have to restitute. You can't, and 265, Redwood 265 said you have to restitute, so you can't withhold the taxes. So it was more in that context. So the Supreme Court said 11B of the Central Excise Act, which provides for refund, also was in challenge. That if I don't claim it under that provision, can I not claim it by filing a writ petition or by filing a suit under section 72 for restitution of the monies that have been wrongfully collected from me? So that was, the discussion was more on those lines.
The suit can be maintained provided subject to unjust enrichment.
No, justice, the majority views seems to be that no suit can be maintained. Of course, Justice Sen and this thing, but they said writ petition can be filed. But of course, the burden is heavily on the SSC to show that he has not passed it on, one. But if he has passed it on, his right is gone to claim it. That is, they brought in the doctrine of unjust enrichment, and only the person who has paid it can make an
Make
application
an application and get it back.
There is,
Whom he should make application,
to the government for,
whoever has collected.
correct.
It did not say anything that if at all you want to seek the refund, it should be within the limitation, it should be in the prescribed form.
11B,
Aspect discuss agilwa.
because 11B provided for, because that's why 11B was also in challenge. 11B, there had to be an application within 2 years or something. That is
It is upheld,
that 11B has been upheld.
upheld.
Yes,
Upheld.
yes.
That means there is a, though 265 does not authorize them to retain the money, which otherwise they could not have levied by way of tax. Still, if you want to seek refund, you have to follow the prescribed
Under the
procedure.
act.
yes,
Under the act, another ruling ankotena.
Howdo?
yes,
That is the ratio.
yes,
That is the ratio.
that is there in the majority
But-
judgment.
But there also the Supreme Court said, if you still have to, if you have foregone that, your right to 26
But that
act, this
does not-
thing, we are not closing it. Suit, they have closed. Suit, they said you cannot.
No, suit is a forum.
Correct.
Whether suit, writ petition is matter of forum.
Correct.
But as of right, the right to forum is only a procedural right. So as of substantive right, right to refund mele, what the Supreme Court says? Supreme Court
So,
say,
right to refund, they said, should be
Subject to-
governed by the provisions of the act.
act,
If the act imposes a time limit for claiming refund.
Within
you
that.
have- You have to claim it within that time.
if it prescribes particular procedure,
You
then
have to-
within that procedure,
Procedure has to be followed.
ಯಾವ್ದದು paragraph?
The conclusion,
Maftlal idya?
I have pointed out all the conclusions of
judgment is
various, so the majority was by Justice Jeevan Reddy.
Sen was a minority, Sen,
Justice Sen dissented. Justice Paripurnan and Justice
Justice
Ahmadi
Ahmadi.
wrote separate judgments, but concurring
But
with.
ಈ judgment ನೀವು ಯಾವ judgment ನಲ್ಲಿ ರೆಫರ್ ಮಾಡ್ಲಿಲ್ವಾ? Input tax ನಮ್ಮ ಹೈಕೋರ್ಟ್ judgment
ಇಲ್ಲ, ಇಲ್ಲ.
ಯಾವುದು ರೆಫರ್ ಮಾಡಿ
Nothing, I mean, we didn't find anything
relevant.
coming out, I mean, any proposition that can be used either by the revenue or by the SC in this matter.
Like it's a case of refund ಅಲ್ವಾ?
no,
Adjustment.
It is a case of my input tax, my refund pursuant to the tax excessively I have paid.
That's what.
Correct.
Even here also, that was the case.
No, there,
Case where statute itself was struck down in some other case. That means authority to levy is taken away. So it is nothing but a case of refund only.
Correct. It is a case of refund, but under 11B, my lord, of the Central Excise Act, there's a provision which says refund has to be made within 2 years in the prescribed form and all that. That is not there under this.
Is there a difference between a refund of tax wrongly paid, excessively paid, etc., and refund of the
Refund that is
input
provided
tax?
under the act.
No, ಇದರ ನಡುವೆ difference ಇದೆಯಾ? Substantive difference ಇದೆಯಾ? The claim for input tax concession and the claim for refund of excess paid tax. ಎರಡರ ನಡುವೆ difference ಏನಾರ maintain
Difference ಏನಿಲ್ಲ, because the thing is this, my lord. Like I said, the duty is to compute the correct tax liability. Now, if I have paid excess over and above the actual correct tax liability as per my calculation or as per the assessing officer's calculation, the balance has to be refunded.
refunded. ಇಲ್ಲಿ ಹಂಗೆ ಈಗಾಗಲೇ ಟ್ಯಾಕ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಮತ್ತೊಂದ್ಸರಿ ನೀವು ಕೊಟ್ರಿ ಅಂತಂದ್ರೆ it is nothing but a refund only.
ಹೌದು.
It may be adjusted, that's another thing.
Correct.
But it's a case of refund only.
It's a case of refund. Of course, input tax credit can also be carried forward.
No,
I
that's a
don't have to
procedural
necessarily claim it as a refund.
refund, but
I
you
can
adjust
adjust it
to
in
some
the
other.
subsequent month against the output tax liability.
That's right.
That's the difference as far as input tax credit or TDS.
So ಅದೊಂದು paragraph ತೋರಿಸಿ ಅದು
My lords,
where it is.
your lordships may come to para 77, which is at page 605.
Herein before.
Herein before. Your lordships may come to the bottom of the page, placetum H,
The language could not have been more
more
specific.
specific and emphatic. The exclusivity of the provision relating to refund is not only express and unambiguous, but is in addition to the general bar arising from the fact that the act creates new rights and liabilities and also provides forums and procedures for ascertaining and adjudicating those rights and liabilities and all other incidental and ancillary matters, as will be pointed out presently. There is a bar upon bar, an aspect emphasized in para 23 above, and has to be respected so long as it stands. The validity of these provisions has never been seriously doubted. Even though in certain writ petitions now before us, validity of the 1991 Amendment Act, including the amended section 11B is questioned, no specific reasons have been assigned as why a provision of the nature of subsection 3 of 11B is unconstitutional. Then they apply Kamla Mills. Then your lordships may come to repeat about placetum D. To repeat, and it is necessary to do so, so long as section 11B is constitutional valid, it has to be followed and given effect to. We can see no reason on which the constitutionality of the said provision or a similar provision can be doubted. It must also be remembered that Central Excise and Salt Act is a special enactment, so and so. Then, my lord, the act is a self-contained enactment. It contains provisions for collecting the taxes which are due according to law, but have not been collected, and also for refunding the taxes which have been collected contrary to law, namely 11A and 11B and its allied provisions. Both provisions contain a uniform rule of limitation, namely 6 months, with an exception in each case. 11A and 11B are complementary to each other. To such a situation, proposition number 3 enunciated in Kamla Mills becomes applicable, where a statute creates a special right or liability and also provides the procedure for the determination of the right or liability by the tribunals constituted in that behalf, and provides further that all questions about the said right and liability shall be determined by the tribunal so
It's only
constituted.
to exclude civil court.
Exclude civil court.
Now, where it said, where statute provides for refund of the excess tax paid,
It has to be, it says 11A, 11B have to be compulsorily followed.
that is the substratum of the case itself.
Yes,
ಎಲ್ಲಿದೆ facts ಎಲ್ಲಿದೆ?
the contention is in para 37, my lord.
Facts ಎಲ್ಲಿ begin ಆಗುತ್ತೆ?
32, my lords.
See the conclusion.
Conclusion.
108 at page 631. It's been summarized, the conclusions.
Majority judgment.
Oh, majority.
Page.
108,
Where
paragraph 108,
refund-
page 631.
Huh?
Page 631, paragraph
108. 108. The discussion in the judgment yields the following proposition. We may forewarn that these propositions are set out merely for the sake of convenient reference and are not supposed to be exhaustive. In case of any doubt or ambiguity in provisions, reference may be made to the discussion and proposition in the body of the judge. Where a refund of tax duty is claimed on the ground that it has been collected from the plaintiff without before. Instead.
Those are categories of refunds, my lord.
Such a claim was necessarily to be provided under and in accordance with provisions of the respective enactments before the authority specified thereunder and within the period of limitation prescribed therein.
Points put together. There are propositions, about 10 propositions. In fact, 12 propositions up to page 635.
Either two is not applicable because statute is not held in unconstitutional. Yaud baratte anta. A claim for refund whether made under the provisions of the act as contributed above or in a suit or so and provision above can succeed only if the plaintiff is established that he has not passed on the burden. That is unjust enrichment. 3.
Correct.
4. It is not open to any person to make a refund claim on the basis of a decision of a court or tribunal rendered in the case of another person. He cannot also claim that decision of the tribunal in another's decision. 4 is not applicable. Article 3 of the Constitution has to be construed in the light of the goal and the ideal set out in the preamble of the Constitution. The concept of economic justice demands that in the case of indirect tax like central excise duty is custom, without the authority of law shall not be refunded to the prisoner. Wages and extra.
Again, unjust. Again, unjust enrichment, 5 also.
5 also unjust.
Because the burden is on the SC to prove that he has not passed on.
While applying the same 70 of contract based on rule of equity. See, rule of equity cannot be excluded than the hold matter. Yesterday, you were saying rule of equity, these things are no much place in the.
That my lords have said on the first day, section 72.
That's all.
With reference to section 72.
That's the difference between English law of contract and
Yes.
Indian law of contract. While examining the claim for refund, the financial chaos which would result in the administration of the state by allowing security is not an irrelevant consideration. When the plaintiff has suffered no real property, passed on the burden of tax to the same society. There is the case ST versus Kannayalan. We have to have been wrongly decided so that it placed. Understood to have laid out propositions contrary to provision at 1 to 7 above. But equally we have. So only decided the of the amendments and the provisions can be to do it.
Ten is with 11 women.
Huh?
10.
10.
Para 10 deals with the provision for refund.
11 V's that refund.
Out.
Yes.
Under central excise.
All except those which arise as a result of declaration unconstitutional. So it have to be preferred and adjudged only under the provisions of the respective enactments. No suit for etc. etc.
So far as the jurisdiction of the high courts under so and so
Is retained.
That's the
Even
same
applies
that-
to all pending proceedings, notwithstanding that the duty may have been refunded to the petitioner plaintiff pending the proceedings are under so and so. For the purchase of making the claim for refund provided he protested that if not passed on to another person. It therefore cannot be said that section 11B is revised to retain the illegally collected tax. ಇದು ಮೆಜಾರಿಟಿ ಜಡ್ಜ್ಮೆಂಟ್
ಹೌದು.
My lords.
both you
Justice
agree.
authored by Justice Jeevan Reddy. My lords want to see the conclusions of Justice Paripurnan, that is at the last.
That is dissenting,
No.
separate judgment,
Separate
concurrent
judgment,
judgment.
but propositions, he also, I mean, reiterating the same thing, but in a different manner. So that is at last 2 pages, parat 346.
Page number,
Page number 741.
for the sake of convenience. In same Midavali.
Oh, almost same. He is put it in a different,
What the author of the, editor of the judgment says? What are the principles laid down according, I think Surendra Malik.
that's at the top first page. The claims for refund have been classified to fall into 3 groups or categories as per the leading majority opinion of Justice Jeevan Reddy and the concurring opinions of Justice Ahmadi, Justice Paripurnan as follows. Unconstitutional levy, where the claim is founded on the ground that the tax was levied under an unconstitutional provision. Then there's a illegal levy, where the claim for refund is based on the ground that there has been misinterpretation, misapplication, erroneous interpretation of Excise Act rules or notification, or an erroneous finding of fact, or in violation of fundamental principles of judicial procedure. And the third category is mistake of law, where the claim for refund is based on decision rendered in another case holding that the levy to be not exigible in law without jurisdiction or illegal or unconstitutional.
Yes, Aditya. Understood. Anything more to be said?
Lords, I just want to conclude with showing your lordships Nandi constructions again.
Yes. Nandi construction,
Nandi constructions,
DB,
my lords.
ನೋಡಿ ನಂದಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲೇ ಇರಬೇಕು.
Hmm. 2016 6 PST. Here, my lord, the
Para 6-7.
yes, the questions are framed in para 5. And as your lordships will see, that this is not a case of input tax credit, but is a case of land cost. But the question is the same, whether the appellate tribunal is legally justified in holding that land cost at 50% that is not claimed in the returns.
ರಿವೈಸ್ ರಿಟರ್ನ್ ಅಲ್ಲಿ ಆದ್ರೂ ಕೇಳಬೇಕಿತ್ತು, ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿ.
So therefore, my lords, to somewhere some judgment that I cited, this is a case that is different from input tax. This honorable court has now, after Nandi, said
equated
no
them.
benefit will flow unless claimed in the return. But one line that I would like to submit, my lord. Para 9.
No reason to differ with the opinion of
Yes.
2 division
First,
bench.
both infinite builders and then centum is reviewed. Infinite builders comes before centum. We have no reason to differ with the opinion of the 2 division benches. Learned counsel for the petitioner has submitted that the question in the aforesaid cases was regarding grant of input tax rebate as a deduction. Whereas in the present case, according to the petitioner, the claim is exclusion of land cost. And as once the authority has accepted it to be higher than 50%, no tax can be levied on such amount which was beyond 50% of the sale consideration. We are unable to accept such submission made by the learned counsel for the petitioner as nothing more than what is claimed by the assessee in its return can be given by the authorities. My lords, I want to pause here. This is an injunction on me to say you cannot give anything more than what is claimed in the returns. And if it is permitted, then the assessing authority or the appellate authorities would be given unfettered powers to grant any such relief which should not even have been claimed by the assessee in its returns. The Act provides for filing a return under Section 35(4) of the Karnataka VAT Act. If the assessee fails to avail of the benefit of filing revised return, then it is only the return which is filed which has to be considered by the assessing officer or other authorities, and nothing more than what is claimed in the return can be granted by the authorities in favor of the assessee for the foregoing reasons.
Yes.
In passing, my lords, one short judgment of your lordships, I just want to refer to. This is on a different footing, but I just want to, this was, your lordships had considered Ecom Gill. And the burden of proof cast by Ecom Gill.
It was section 70.
70. But I would just request your lordships to take para 5.1. The first contention of AG appearing for the revenue is that the very approach of the tribunals to the appeals of the assessee and cross appeals of the department is juridically defective, stands adumbrated for the reasons that are not far to seek. A reading of statements of objects and reasons of the Act make it clear why the burden of proof is cast upon the assessee under Section 70. While the VAT regime, and here, my lord, is my emphasis, while the VAT regime was introduced to give relief from the cascading effects of tax, which is tax on goods, the enforcement of the Act relied heavily on transparency, self-assessment, and declaration, timely and specific invoices, and truthful and timely filing of returns. Further, structure is designed to give full credit or set off for tax already paid in the chain of value addition in earlier points of sale would only work if the component of tax reaches the coffers of the state, so and so. My emphasis is your lordship's interpretation of this statement of objects and reason, self-assessment and declaration, timely and specific invoicing, and truthful and timely filing of returns. Beyond that, my lord, this is not relevant. It's on a completely different fact pattern. With my lord, with this, I pray your lordship's indulgence, my lord. My STRP may be allowed. And I'm grateful to your lordships for the time and opportunity granted, my lord, for patient hearing.
Yes, I'll start with the last sentence that he said. In this case, first, the STRP cannot be allowed for the reason that there's already a decision in my own case by a different bench. I submitted on the first day itself. If at all your lordships even don't agree with my proposition, the propositions that I have cited, the only
Ways to
is
refer it
to a larger bench. That is one. I'll start big. I just wanted to, since that was the last statement made by Leonard Trent. Now, my lord, as far as your decision, I'll go backwards.
No,
Your
that
lordship's
decision-
decision was in the
that
context
decision
of,
May not be.
correct, was in the context of,
No, may not be. No, not
Because-
spend time on that. Go
Yes.
to other decisions.
correct.
He said it, what is the object of enacting that new
Object-
regime is the
That is
accept-
only one or two objects your lordships have called out. There are other objects also which I pointed out, that input tax credit, to say that input tax credit is virtually not just a concession, once a concession.
It's
is given,
object also.
It's object also, because entirely, as your lordships rightly said yesterday,
Yeah.
we cannot read just one provision. We have to read that provision in the context of the section, the chapter, this thing, and the entire object of the Act as a whole. That's what I've been saying. I'll just, the decisions, my lord, cited by my learned friend in reply, I'll just deal with that. And Pune, my lord, I will not deal with because the proposition, when SLP dismissed in one line, SLP dismissed even with a discussion, it's not binding under 141 and all that. I don't think we need to labor. Now, my lord, gets Justice Rumapal judgment, which my learned friend cited, as I pointed out at that time itself, that was a case of claiming deduction, which is different from claiming tax credit.
But after more Justice Vinit Sarin's judgment,
Justice
that
Vinit
difference does not much
No, no,
lie
Justice
at all.
Vinit Saran's judgment also has to be understood in a context. I'll come to Justice. Since my lords are on Justice Vinit Saran's judgment, kindly see the facts in Nandi's case, because my lord, the ratio has to be drawn from the facts of that case.
Centum is also considered in that.
Centum is also considered in that. Kindly see what are the facts in Justice Nandi, Nandi Constructions with his Justice Vinit Saran's case, decision. Paragraph 6. My lord, para 5 is the question, are the questions. Kindly see para 2 onwards. Let us understand the facts of that case before, because what I am claiming is, like I have been pointing out from the beginning, my lord, what I am claiming is tax that I have already paid. You should give me credit for that. That's all I'm saying. Input tax credit is the tax I have paid in advance. Please give me credit.
Para 9,
Yes.
your argument was made. It was a matter relating to input tax. Therefore, that principle cannot be applied here.
Here, because what was being claimed is 50% of land cost. My lord, land cost, what happens is, this is a case where it's a case of a builder. It's a works contract. My lord, whether the construction activity, whether developers, when they develop buildings and all that, whether it's exigible to tax, Raheja and all that went up to the Supreme Court. Supreme Court L&T said ultimately it is liable to tax, but you have to give them deduction for the land cost.
Yes.
This 50%, 40%, 45% is not provided under any act. What is the deduction to be claimed for land cost is not provided under any act. It has to be established by facts, on facts, that this is the land cost I have incurred. Under works contract, my lord, you cannot tax anything other than goods. Land is immovable property. You have to remove that land cost from the cost consideration that you have received and claim it, offer the remaining to tax. In this case, if my lords kindly see paragraph 6, what the SSC there did is, the main issue to be decided by this court is as to whether the petitioner can be granted benefit over and above what has been claimed in the returns. Admittedly, the claim of the petitioner in the returns filed for the tax periods was at 45%. Though the assessing officer allowed only 40%, the first appellate authority granted the benefit of 45% towards land cost. The question now to be decided is whether, unless a claim is made in its return, any benefit beyond benefit claimed in the return can be considered and allowed. Now, I on fact said, I had to determine the land cost on facts. What is my agreement with the landowners? I have to determine and say, this is the land cost I want to claim.
Where it's a question of fact,
Fact.
this is true. Where it is question of law, this will not come in the way.
In a case of tax credit, this decision cannot apply because this decision was in a
But
different.
that argument was made in this decision.
Huh.
Court said, no, we don't agree with your argument.
Correct. They said you have to, even if I have not made the claim, but what was the nature of the claim has to be seen, my lord. That's what I'm submitting.
It's fact-based.
Is it fact-based?
Or it's a law-based?
Is it a deduction or a concession, as my learned friend is saying, or is it something inbuilt, something like a tax credit? That nature of deduction that I'm claiming is what I have to be. As far as input tax credit is concerned, what I am submitting it is tax paid in advance. How can you retain it? Because deductions, land cost deduction and all that is to determine the tax.
It's a factual, firstly factual. You can't give more benefit on the facts which are not pleaded. Is the substratum of that. That's your submission.
That's exactly what I
Yes. Next point.
My lord, again, Centum, my learned friend read one paragraph. I'll just take your lordships to the facts of centum. Otherwise, my lord, I'll do one thing, my lord, since we are short of time and this has been
ಒಂದು
going
ರೈಟ್
on.
ಅಪ್ ಕೊಟ್ಬಿಡ್ತೀರನ?
ನಾನೊಂದು ಟೇಬಲ್ ತರ ಕೊಡ್ತೀನಿ.
ಹೇಳಿ,
I'll
ಬರ್ತೀನಿ.
give one table of the decisions against the SCs, decisions in favor of the SC.
ನೀವು ಅದೇ ರೀತಿ ಅವ್ರು ಕೊಟ್ಟಂತ ಡಿಸಿಷನ್ಸ್ ಮೇಲೆ ನಿಮ್ ಕಮೆಂಟ್ಗಳು, ನೀವು ಕೊಟ್ಟಂತ ಡಿಸಿಷನ್ಸ್ ಮೇಲೆ ಅವ್ರ ಕಮೆಂಟ್ಗಳು, ಎರಡರ ನಡುವೆ ಯಾವ್ದನ್ನ ನಾವು ಚೂಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ.
ಹೌದು.
That will be great.
I'll just clarify only two decisions which my learned friend cited today and yesterday.
Only
One is that Madras High Court Sutherland.
ಹಾ.
That I pointed out, my lord, that was a case of transition. Section 140 of the GST Act did not give credit for education cess and all that, but it gave credit for-
ಅದರ್ ಬೆನಿಫಿಟ್ಸ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ರು.
So
ಇದನ್ನ
therefore,
ಕೊಡ್ದಂಗೆ ಇರಕ್
it is
ಬರಲ್ಲ
on the
ಅನ್ನೋದು
same
context.
lines, like the
Pending
other
before the
decisions which my
Supreme Court.
learned friend read on constitutional validity. I am not saying that where there is a restriction, that was a slightly different case. So Sutherland's also with great respect,
Actually
my lord,
different.
factually different. Then
ಅಲ್ಲ ಅವ್ರನ್ನ ಸದರ್ಲ್ಯಾಂಡ್ ಅದನ್ನ ಹೇಳಿದ್ ಬೇರೆ, ಇಟ್ಸ್ ಓನ್ಲಿ ಎ ಕನ್ಸೆಷನ್
ಹೌದು,
ಅಂಡ್ ನಾಟ್ ಬಿಯಾಂಡ್ ದಟ್ ಅನ್ನೋ ಒಂದೇ ಪಾಯಿಂಟ್ ಮೇಲೆ.
ಹೌದು. ಅದೇ that concession versus right, all the decisions cited by my learned friend to say that this is in the nature of concession was in a context of
ಮೂರೇ ಪ್ರಪೋಸಿಷನ್ ಅವ್ರು ಮಾಡಿದ್ದು.
ಹೌದು.
ಒಂದು, ಇಫ್ ಯು ವಾಂಟ್ ಟು ಸೀಕ್ ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಕನ್ಸೆಷನ್, ಯು ಶುಡ್ ಡೂ ಇಟ್ ಇನ್ ದಿ ರಿಟರ್ನ್. If not in the return, in the revised return, subject to law of limitation.
Correct.
Because section 35, read with rule 38, read with the forms prescribed, everything is provided there. Unless you claim that, nothing can be done.
Correct.
The whole gist of
And
this.
whether those provisions
And
can be.
secondly, it is only a concession. Therefore, as a matter of right, you cannot seek. And that too, concession is by way of exception to the statute.
Correct.
That section 10 ಗೆ 14 ಗೆ no 10 ಗೆ 11 ಗೆ 14 will be an exception.
Yes.
ಹಾಗಾಗಿ
11 is a prohibition
exception
of 10.
ಕನ್ಸ್ಟ್ರೂ ಮಾಡುವಾಗ ನೀವು very strictly have to bring your case within the exception ಅನ್ನೋದು. Thirdly, in support of his contention that it is a concession, he has cited these decisions. Lastly, to add to, he says, unless claim is made in the prescribed form and within the prescribed period, even if what we have collected is wrong, you cannot claim it back.
Correct.
These are his propositions.
These are his propositions. I'll just answer what my learned friend says, that to say that 11 is an exception to 10 is not correct. Because if my lord see the language of section 10, 10 says subject to the restrictions under 11 and so and so. I am entitled for input tax credit. To say that this rebate is being given to me as an exception is not correct.
No, restrictions are treated by the Supreme Court as exceptions.
Correct. No doubt about that. Subject to the restrictions, yes.
Because those restrictions you have to prove
Correct.
that these
Now-
restrictions do not apply to me ಅಂತ ತೋರಿಸಬೇಕು.
Therefore, my lord, the fact that there is no restriction on me is not disputed to claim. Their claim is if I had claimed it in the return, I would have given it. You have not claimed it in the refund, therefore I am not giving it. That's all it is.
ನಿಮ್ದು ಇನ್ನೊಂದು ಡಿಫರೆನ್ಸ್ ಇದೆ. It is not a case of not making the claim at all.
At all. Because most of the decisions.
Question is, what should be the rate?
Correct.
I wrongly mentioned the rate.
Understood the rate as something else.
That is wrong.
It turned out to be something else.
That they should have themselves done. Instead of that, at least when I applied for, they should have done.
Correct.
Easy work.
And most of the other decisions, infinite and all that, my lord, I can point out from the facts, I'll put it in the table. These are cases of no return filed or returns filed after an inspection. 39.4, if your lordships kindly see the language, 39.4 says, if a revised return is filed pursuant an inspection, it's not a revised return, even if filed within 6 months.
It's a return only.
It won't be treated as a return. A revised return filed within time, but pursuant to an inspection. If officer goes and inspects, then I hurriedly go and file a revised return saying
is
I am
no return.
compliant to this thing, that is no return. The officer can still do a best judgment assessment. That's why, my lord, all the safeguards are there under the act. Now, as far as the one very major point, my lord, which I submitted on the first day, why I said this amendment 10.6, my lords my friend has read. Kindly see, 10.6, ultimately they did bring in a restriction. by way of 10.6. But when did they do it? In 2016.
ನಿಮ್ದೇನು ಅಂದ್ರೆ ದೇ ಆರ್ ಬೆನಿಫಿಷಿಯಲ್ ಟು ದಿ ಡೀಲರ್ ಓನ್ಲಿ ಅಂತ ನಿಮ್
No, no, that is proviso to 10.3.
ಹಾ ಪ್ರೊವಿಸೋ ಟು 10.3.
That is proviso to 10.3. Kindly see 10.6. Proviso, this honorable court said, is clarificatory and declaratory. That is
therefore retrospective ಅಂತ.
therefore retrospective, and they granted me the benefit and they said that has watered down
Correct.
this thing. Kindly see 10.6.
10.6.
My lords.
ಬಟ್ ಇದ್ರಲ್ಲಿಲ್ಲ.
Allot have 10.6, 10 subsection 6. Now kindly see 6 was introduced with effect from 1/4/2016.
Correct.
It is a subsection that is introduced. Notwithstanding anything contained in this act, input tax deducted by a registered dealer to calculate net tax payable
ಒಂದ್ ಸೆಕೆಂಡ್
is,
ಕನ್ನಡದಲ್ಲಿ ಇರೋದಕ್ಕೆ
My lords, English is thereafter.
ಹಾ ಯು ಆರ್ ರೈಟ್.
notwithstanding anything contained in this act, input tax deducted by a registered dealer to calculate net tax payable is provisional to a dealer who fails to furnish or furnishes incorrect or incomplete particulars for preparation of the return in the prescribed form electronically through internet in the manner specified in the notification issued by the commissioner under first proviso to section 35, and the jurisdictional local VAT officer or VAT sub-officer shall assess such dealer for such tax period by disallowing input tax claimed by him and issue demand notice. That is one. Kindly see the proviso also.
Yes.
Provided that where an assessment has been made under this subsection and the dealer subsequently furnishes particulars for preparation of the return in the prescribed form and furnishes correct and complete particulars for preparation of the return electronically through internet in the manner specified in the notification, the jurisdictional officer shall withdraw the assessment, but the dealer shall be liable to so and so. So they say this, my learned friend submission was this subsection was introduced to legislate or to make it a law what Centum has said. Now this was introduced only in 2016. It was not there prior. Now I have from the beginning, from day one, what I have been saying, my lord, if there has to be any restriction to my right under section 10, the restriction has to be prescribed under section 10 itself.
10 to 18, 19 ತಕ್ಕ ಅಂತ.
My lord?
Restriction
Ha.
11 to 18 which you said.
Those 11 to 18 only will apply because 10 specifically says that
No
those are the
restriction can be brought in by machinery provisions.
by machinery provisions. It requires a substantive provision to restrict it. That substantive provision came only with effect from 2016. So prior years, that restriction itself cannot be read into the act.
Otherwise they would not have enacted.
Enacted it. Where is the need for enacting it? They realized their mistake after Sonal Apparels, Kirloskar and BML, and they brought in this amendment.
Lords will see that all judgments that have been cited, which is Nandi, Centum and Infinite Builders, pertain to a period prior to this. The law declared.
ಹಂಗಾಗಿ ತಗೊಂಬಂದಿದ್ದು ಅಂತ ಇವ್ರು ಹೇಳೋದು.
ಅದೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
No, the law declared that the return is required is unequivocal in those judgments.
Correct.
Return ಇರ್ಬೇಕು. That was merely implemented. That was implemented.
Otherwise ಯಾಕೆ ಮಾಡಿದ್ರಿ ಅಂತಾರೆ ಅವ್ರು.
Your lordship.
If
ಇದು
you could,
merging
if that was
sometime ನಲ್ಲಿ-
sufficient, where was the need for this?
ಹಾ ಅಂತ. A law, that's what his submission is.
Well, virtually it will be giving retrospective effect to this provision
In
when the
fact,
provision doesn't suggest.
In other words, because of this amendment, your submission need to be accepted ಅಂತ ನೀವು ಹೇಳೋದು.
ಹೌದು.
Had it been there, you could not have made such submission.
I
at
could
all.
not have made that.
Anyway, ಒಂದು ಶಾರ್ಟ್ ಒಂದು ನೋಟ್ ಅನ್ನು ಮಾಡ್ಕೊಂಡು.
I will.
Lily Thomas case, the Supreme Court clearly says that when the court interprets law, it dates back to the date of the legislation.
Interpretation, yes.
Yes.
Interpretation ಇದ್ದಾಗ.
Prior to 10.6, also, the court has unequivocally interpreted what the requirement for return is.
This is only declaratory of what was said ಅಂತನಾ.
Yes, yes, yes.
ಹಂಗ ಲ್ಯಾಂಗ್ವೇಜ್ ಹಂಗಿದೆಯಾ?
No.
if this is tabulated and compared to Infinite, Centum and Nandi, exactly the same proposition.
Legislature has enacted the rulings ಅಂತ ನಿಮ್ contention.
Yes. Yes.
ಅವ್ರು ಹೇಳಿದ್ರು ಆ ಎಕ್ಸರ್ಸೈಸ್ ಲೆಜಿಸ್ಲೇಚರ್ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ because law was there in the precedent. The very fact that they wanted to bring something new is because of this ಅಂತ ಇವ್ರ contention.
That is,
Because there are other decisions of this honorable court which said centum is not correct. Centum is distinguished.
neither of us were looking at 10.6 until your lordships asked, what is the state doing?
No, I'm just, because my
Don't
learned
forget.
friend pointed out, I'm saying this also supports my argument. This also supports my argument that the restriction, if any, had to be there under 10, or the other provisions that are there providing for restrictions. That restriction, if at all, has been brought with effect from 2016. If that restriction has to be imposed for earlier years, it would be virtually giving retrospective effect to that provision, which cannot be done.
But it is not as if the High Court has looked at 10.6 and says, I am applying it retrospectively.
But there are conflicting decisions.
Conflicting ಇಂತ confusing decisions
Confusing.
ಜಾಸ್ತಿ ಇದಾವೆ. Yeah. Okay. Thank you so much. We learned really, we learned.
No, it was a
lot.
learning
We
experience,
learned
equally for
learning
us.
experience. It was a learning experience. So much interpretation, so much. Once for all, we'll decide. Maybe we have taken more time. ಬೇರೆಯವ್ರಿಗೆ ಅನ್ಸ್ಬೋದು ಎಷ್ಟು ಟೈಮ್ ತೋತಾರಪ್ಪ ಈ ಚಿಕ್ಕ ವಿಷಯ ಹಂಗಿರಲ್ಲ
ಇಲ್ಲ ಇಲ್ಲ.
ಆ ರೀತಿ
It has to be very careful.
ಹೌದು.
Any tax matter, for that matter, in fact, my lord, if I was, dealing with Ecom Gill, I have something else to say, but anyway, in an appropriate case, I will trouble your lordship.
result.
Great.
Thank you so much to both of.
By Monday, we'll
Thank
file
you,
the
sir.
written submission. By Monday.
ಹಾ
ಇವತ್ತು Friday, Monday.
ಬಟ್ ನಾವು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡ್ತೇವೆ.
ಆಯ್ತು.
ನಮ್ದು ವೇಟ್ ಮಾಡಲ್ಲ ನಾವು. ನೀವು ಯಾರ್ಯಾರು ಕೊಡ್ಬೇಕು ಅನ್ನೋರು ಕೊಡಿ. ಕೊಟ್ರೆ ದಟ್ ವಿಲ್ ಬಿ ಆಫ್ ಗ್ರೇಟ್ ಹೆಲ್ಪ್ ಟು ಅಸ್. ಬಟ್ ಅವರ್ habitually we start working on them.
One or two extra days. Okay. Because I am permanently in your lordship's court. Then I go to the government advocate chamber, then private chamber, 1 or 2 extra days if I'm given.
all right. ಒಂದು 2-3 days ನ ಕೊಡಿ.
I'm
ಬಿಫೋರ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ.
Monday or
ಟ್ಯೂಸ್ಡೇ ವೆನಸ್ಡೇ ಒಳಗೆ ಕೊಡ್ತೀರಾ?
Wednesday.
ವೆನಸ್ಡೇ ಕೊಡಿ. ಅದಾದ್ಮೇಲೆ ನಾವು ಅಲ್ಲಿ ವೆನಸ್ಡೇ ತನಕ ವೇಟ್ ಮಾಡ್ತೀವಿ. ಇಲ್ಲ ಬಂದು ಥರ್ಸ್ಡೇ ಜಜ್ಮೆಂಟ್ ಬಂದ್ರು ಬಂತೆ. ಓಕೆ.
Court Master, sir. Court Master, sir. Sir, in item number 1, Nordex India Private Limited, I just wanted to know what's the date and what happened. Court Master, sir. सर आपकी आवाज नहीं आ रही है. Court Master, sir.
Tell me what is, hello, Anshika.
Yes, sir. Sir,
Tell
in
me.
item number 1, Nordex India Private Limited, I just wanted to know what happened.
Yes, taken time.
Department has taken time
Yeah.
for, so
For,
for complying.
Paying process fee.
So
Paying
sorry.
process fee.
Okay, sir. Okay, sir. So any date that has been given?
No date, madam.
Okay,
will be
list
listed
after
after
2
2
weeks or 4 weeks?
2 weeks, 2 weeks.
Okay, sir. Okay.
Till date ಅಂತ next month ಅಲ್ರಿ. ಅದೇ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. Next till date ಅಂತ ಬಂದ. ಹೇಳ್ತೀನಿ ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಬಿಟ್ರೆ petition AG notice ಕೊಡಿ.
ಗೊತ್ತಾಯ್ತು ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಬಂತು ಅದಕ್ಕೆ ನಮ್ಮಲ್ಲಿ ನೀವಿದ್ದು
ಸೈನ್ ಬರ್ದಿರ್ತಾರೆ ಆ ಡೇಟ್ AGA ಇಲ್ಲಿ ಹೇಳ್ಬೇಕಾಯ್ತು ಸರ್ ಆರ್ಟಿಕಲ್ 141 ಬಿಡಿ ಸರ್ ಪೆಟಿಷನ್ ರೆಸ್ಪಾಂಡ್ ಆನ್ಲೈನ್ ಡೈಲಿ ಬಂದು ಅಟೆಂಡೆನ್ಸ್ ಆಗ್ಬಿಟ್ಟು ಏನು ಮಾಡ್ತೀರಾ ಏನಾಯ್ತು ಏನು ಮೇಡಮ್ ಮೇಡಮ್ ಹೇಳಿದ್ರೆ ಏನ್ಸಿ ಅಂತ ಏನ್ ರೀತಿದಾರೆ ಅವ್ರು ಬರ್ಬೇಕು ತಾನೆ ಮೇಡಮ್ ಅಲ್ಲಿ ಒಂದು ಫಿಕ್ಸೇಷನ್ ಯಾವೋಯ್ತಪ್ಪ ಆಯ್ತು petitioner AGA petition number ಆಯ್ತು ಇನ್ಸೆಕ್ಟ್ ಇಲ್ಲಿ ನೋಟ್ಸ್ ಇದೆ ನೆಕ್ಸ್ಟ್ ಇದೆಲ್ಲಿ ಯಾವುದು ನಾಳೆ ಫಿಕ್ಸ್ ವೀಕೆಂಡ್ ಗರ್ಲ್ಫ್ರೆಂಡ್ ಜೊತೆ ಪಾರ್ಟಿ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ ಸುಮ್ಮನೆ ಇಲ್ಲಿ ಊರ್ ಅಂತಾರೆ ಏನ್ರಿ ಸುಳ್ಳು ಹೇಳ್ತೀರಿ ಇರೋದ್ ಹೇಳ್ರಿ
ಸರ್ ನಮ್ ವೀಕೆಂಡ್ ಸರ್
ಹಾ
ನೀವು ಆಫೀಸ್ ಹೋಗಿ ಬರ್ತೀರಾ ಏನು ಇಲ್ಲೇ ಬೇರೆಯವ್ರು ಬರ್ತಾರೆ
ನೀವೇನೇ ಎಷ್ಟೇ ಕಟ್ಟಿದ್ರು ಇದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಎರಡು ಮಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ ಯಾಕಂದ್ರೆ ಸಾಹೇಬ್ ನಮ್ದೇ ಕೊಡೋದು ಇವ್ರು ಏನ್ ಕೊಡೋದು ಅಂತ ಎರಡು ಮಿಕ್ಸ್ ಮಾಡಿ ಪೆಟಿಷನ್ ಅಂಡ್ AGA ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಊಟಕ್ಕಾಗತ್ತೆ ಹಾ ಹೋಗತ್ತೆ ಸಾಹೇಬರು ಬರೀತೀರಾ ನಿಮ್ದೆಲ್ರಿ
before both of them have come to an understanding to seek review of the order before this honorable court, and authorization could be granted to him, my lord.
Him.
Could be granted to me, whatever is given to him.
ಮತ್ ಕೊಡಿ ಬರ್ದು ಕೊಡಿ ಆ ರೀತಿ.
ಅದೇ ಹೇಳಿದ್ದಾರೆ ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ವಕಾಲತ್ ಒಂದ್ ದಿವಸ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವ ಅಂತ
ಈಗಲೇ ಬರ್ಕೊಡ್ತಾರೆ.
ಬರ್ಕೊಡಿ ಈಗ.
ಬರ್ಕೊಡಿ. Mother, my lord, try to help the petitioner, my lord, because he is unemployed.
Okay.
That is the reason, my lord. We would not have troubled your lordship, my lord.
ಕೊಡಿ. ನೀವಿಬ್ರು ಒಪ್ಪಿದ್ರೇನು? ಅವ್ರು ಒಪ್ಪಿದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ದಟ್ ಒನ್ ಯು ಕನ್ಸಿಡರ್.
Yes, sir. ಬರ್ಕೊಡ್ತಾರೆ.
ಹಸು ಅವ್ರಿಗೊಂದು ಪೇಪರ್ ಕೊಡಿ. ಚೆನ್ನಾಗಿ ಬರ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ಕ್ಲಿಯರ್ ಕಟ್ ಆಗಿ, ಏನಾದ್ರು ಅರ್ಧಂಬರ್ಧ ಬರ್ಕೊಂಡ್ ಬರ್ಬಾರ್ದು.
Serial number 4, Subramanya. Subramanya PD, Dattatra Agde.
AGA is requested, issue notice, AGA is requested to accept notice. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
R3 to 4, private parties.
Emergent notice to the rest. R5. Okay, sir.
Number 4, my lord, I am for the.
All right, notice third.
Serial number 5, Raja Subramanya Bhatt.
For the petitioner in this, my lord, this is a review petition filed by me. Wherein in the order, it was referred to, perhaps it is my mind, the facts are not properly put forward before this court while passing this order. The annexure C is the order issue delivery warrant. That is, I have placed orange label there. And the order.
Delivery warrant dated 36/2018.
ಹೌದು ಹೌದು, that is annexure C ಅಂತ ಹೇಳ್ತಾರೆ writ petition ಅಲ್ಲಿ, wherein this petitioner was not appeared in this because notice was not served. Notice was not ordered. Even at the time of admission, it was ordered. 13 June 2018 is annexure C. That is that delivery warrant.
By whom it is issued?
By the executive court.
Huh?
Executing court in the execution petition.
It cannot give because under order 26 rule 13.
That period was over. After receiving all the commission report and confirmation of the report, this was the final decree proceeding for seeking for execution of the decree and delivery of warrant.
But deputy commissioner is the person.
That was all said. That was all.
Stage is over.
Stage was over by that. This is annexure C is delivery warrant by the court to the judgment debtors. Delivery warrant issued. Annexure D is possession given merger. That also I have placed label in orange second.
But now deputy commissioner, assistant commissioner, but the deputy commissioner ಮಾಡ್ಲಿ ಅಂತ ಹೇಳಿದ್ದೇವೆ.
That was that period.
You have said that stage is over.
ಹೌದು.
But what would happen if the deputy commissioner does it?
That was not not to precipitate ಅಂತ ಹೇಳಿಲ್ಲ, interim order ಇದೆ. Not to precipitate ಅಂತ ಹೇಳಿದೆ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇಲ್ಲಿ ಇದೆ ಈ
ಇದರ execution proceeding shall be accomplished without brooking any delay.
ಇಲ್ಲ ಇದರಲ್ಲಿ not to precipitate ಅಂತ ಹೇಳಿ interim order ಇದೆ.
ಆಯ್ತಲ್ಲ, interim order ಆಯ್ತು. ಇದರಲ್ಲಿ ರಿವ್ಯೂ ಎಲ್ಲಿದೆ ಅಂತ?
My review petition, this is petition is a review petition.
Correct. Where is the error apparent on the face of the record?
That is annexure C, that is interim, that final order passed. Final order passed, setting aside annexure C and D of the writ petition.
We have only said that the deputy commissioner shall accomplish it
Now
because section 54 requires that.
That will amount to second exercise now.
ಈಗಾಗಲೇ ಅದು ಆಗಿದೆ ಅಂತ.
ಆಗಿದೆ, ಆದ ಪ್ರಕಾರ in conformity this delivery warrant issued.
ಯಾರು ಅಪೋನೆಂಟ್? ಅಪೋನೆಂಟ್
ಅವ್ರು ಬರುದು ಇಲ್ಲ.
ಮುನಿಯಪ್ಪ CR ಗೌಡ.
The subject writ petition was disposed of by this court by judgment dated 18/9/2019, wherein paragraphs 2 and 3 read as under. Next paragraph. Learned counsel appearing for the review petitioners submits that there was no occasion for this court to voiding annexures C and D, namely the delivery warrant dated 30 June 2018,
18.
in as much as the proceedings under the at the hands of the deputy commissioner in terms of section 54 of CPC were already accomplished, and that the delivery warrant is a further step in aid of that.
Yes. In
First-
execution 33 of 17.
In execution
The
33 of
33 of
2017, and therefore the order needs to be recalled. First off, despite service of notice, the respondents have chosen to remain unrepresented. First off, however, that would not deter the court from adjudging the cause brought before it, in accordance with law. First off, next, having heard the learned counsel for the petitioners
Deliver.
and having perused the petition papers, this review is allowed, and as a consequence, the allowed in part, and as a consequence, the delivery warrant dated 36/2018 needs to be executed.
That is also over.
That is also over now.
Howdo?
Then what remains in this?
30th June 18,
Yeah.
that is a merger I have produced.
Alright, ಮುಂದೆ
At the-
ನಡೀತದೆ ಇದ್ರಲ್ಲಿ.
ಏನಿಲ್ಲ, that is, that order needs to be corrected to that extent only.
ಅಲ್ಲೇನ್ ಬರ್ದಮ್ಮ? Is allowed in part, first off. The
And
the
delivery warrant,
we have, it is noted that the delivery warrant dated 36/2018 is already executed
13
by
6,
trying
that is a drawing merger
Mahajar
dated 30th June 18.
on the on 30 on the same day.
ಇಲ್ಲ 30,
On
30th.
On matadu 30.
Earlier is 13/6,
No, you have said. 30.
annexure C.
But come to page 7, internal page 7 of the order.
ಇಲ್ಲ,
ಅದು
order.
1-3 ಮಾಡ್ಬೇಕಾ?
ಹೌದು.
Delivery warrant
Annexure
should be
delivery warrant is 13th June.
13/6/2008 is already accomplished by drawing Mahajar dated
30th June.
2018. With this observation, disposed of.
Yes,
Next paragraph.
no,
With the above observations, matter is disposed.
nothing remains to be considered. Much obliged.
Next.
Scene number 6, Shanmuka GC. Scene number 6, Shanmuka.
ಏನಿದೆ ಕೊಡಿ. ಏನಿಲ್ಲ ಕೊಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ನನಗೆ ಸಾಕು. Yeah, what is this matter? You are not yet appeared.
There appears to be from the record.
Ah.
There was a dispute. There was an arbitration clause. First writ petition relegated them to arbitration.
Ah.
Second writ petition was filed.
Ah.
It was brought to the attention of this honorable court that award in the arbitration has been passed. 34 has not been filed. Liberty was granted to pursue the 34, and the time spent in pursuing the writ petition was excluded from limitation. There is, it was held that the remedy under,
Challenge to the award.
he has to challenge. it.
34 ನಲ್ಲಿ ಹೋಗ್ಬೇಕಾ?
34. The arbitration plus the 34, as your lordships have had, is wider than
Writ jurisdiction.
Under 227.
What is that he finds a fault with?
Kindly see 5A.
5A.
5BLA is some lack of assistance extended by counsel, but it is dehorse any assistance extended by counsel.
34 is the only.
And he misinterprets the order saying, asking the petitioner to approach the very authority again. No, he has to go in 34 to the 34 court, competent district court. Then he says in C, the 1996 Act is not referred. There is no requirement that when I have an arbitration clause that I have to refer to the Act. I simply have to say that it has to be resolved by arbitration.
The writ petition involved a claim for a certain sum of money. First stop. In terms of arbitral award, coordinate bench of this court had disposed of another writ petition number 33544 of 2010 on 23/7/2012. In view of the award. First stop. That award became the basis for disposal of this petition as these petitions as well, reserving liberty to the petitioners to invoke provisions of section 34 of the Arbitration and Conciliation Act. First stop. A concession was shown observing that the period spent in prosecuting these petitions shall be liable to be discounted while computing the period of limitation for laying a challenge to the subject awards. First stop. I do not find any error in the order put in review. As submitted by learned AGA, who on request appeared for respondent, the official respondents, respondents 1 and 2. All respondents and
All respondents.
all respondents. Respond. First, in the above circumstances, review petition is disposed of. However, the period spent in disposal of the during the pendency of the review petition shall also be discounted while invoking remedy under section 34 of the Act. Yes.
Number 7.
Same.
The subject matter of this petition, this review petition is substantially similar to the one in RP 514/2022, wherein no substantive relief has been accorded to the review petitioner. Wide order dated ಇವತ್ತಿಂದ ಹಾಕೋಬೇಕು. First stop. Next paragraph. Like case should be decided alike, and therefore this petition also meets the same fate, with the concession as has been granted in the coordinate case. Next, first may respond to first. Next,
Seal number 8, government advocate. Sumantel Bharadwaj.
I appear for respondent means.
ಏನಿದೆ?
The cause of exorcism is involved.
Ah,
Your lordship was pleased to allow the writ petition filed by the respondent
ah,
and directed them to grant the land. On their submission, they have only identified the land during the writ proceedings.
ah.
My
And they
office-
filed affidavit memo also that they will grant the subject land. Based on their submission, your lordship was pleased to dispose of the writ petition, directing them to grant their land within a period of 4 months.
Ah.
Which they do not comply, my lords. We filed a contempt petition. In contempt petition, they made a submission, review is pending. So contempt petition came to be disposed of in view of.
What is that review?
My officer has made an incorrect statement as to the land that is to be granted, survey number 67, which happens to be forest land. I am not able to comply with that. I have,
ನೀವೇನು ಲ್ಯಾಂಡ್ ಲೂಸರ ಅಥವಾ ಡಿಫೆನ್ಸ್
Defense, my lords.
ಡಿಫೆನ್ಸ್ ಪರ್ಸನ್
Different purpose.
ಮತ್ತೆ ಅದ್ರ ಬೇರೆ ಲ್ಯಾಂಡ್ ಕೊಡ್ಬೇಕಲ್ಲ?
ಕೊಡ್ಬೇಕು. I have undertaken to do so.
ಯಾವ ಲ್ಯಾಂಡ್?
I've, my lords, it is communicated, your lordships may kindly see para 9.
ನಮ್ಗೆ ಅದೆಲ್ಲ ಬೇಡ. ಯಾವ ಲ್ಯಾಂಡ್ ಕೊಡ್ತೀರಿ ಹೇಳ್ಬಿಡಿ.
Site is identified and,
Oh, my lords, what they are submitting, my lords, the survey number, what now they are saying forest department, it's not correct, my lords. I have produced I am having the RTC extracts.
Yeah.
Even in 2023 also, they have granted the land, the very same survey number. But when it comes to exorcism, they are making.
ಫಾರೆಸ್ಟ್
the same.
ಲ್ಯಾಂಡ್ ಅನ್ನೋ ಬಗ್ಗೆ ಏನಿದೆ ಪ್ರೂಫ್?
I'll have to.
It's not forest land, my lords. It's a government land.
ಎಲ್ಲ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್.
Sorry.
ಅದು ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಅನ್ಲಿಕ್ಕೆ ಎಲ್ಲಾದ್ರೂ 1909 ಆಕ್ಟ್ ಕೆಳಗಡೆ ಇರುವಂತ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ಬೇಕು, ಅವಾಗ ಬರುತ್ತೆ. ಇಲ್ಲಪ್ಪ ಫಾರೆಸ್ಟ್ ಲ್ಯಾಂಡ್ ಆಗಲ್ಲ.
In which case I'll take instructions.
Permit AGA to hear that the subject land earmarked for the grant to petitioner and ex-defense personnel a forest land, so that some other land can be granted if assertion is true. First, call after 2 weeks. Yes.
First door matter.
ಏನೋ ಸೈಟ್ ಕೊಡೋದಿದ್ರೆ ಬೇಡ ನಿಮ್ಗೆ? ಸೈಟ್ ಬೇಡವಾ?
Right, but land is available, my lords, according to my instructions.
ಸೈಟ್ ಬೇಡ ನಿಮ್ಗೆ?
First door matter, seal number 3. See, Shivaramu.
Respondent number 4, man.
ಬಡಿ. ಯಾಕೆ ಈ ಫಾರೆಸ್ಟ್ ಬ್ರದರ್ ಆದಿತ್ಯ ಡಿಫೆನ್ಸ್ ಪರ್ಸನ್ ಅಲ್ಲಿಗೆ ಅನ್ನೆಸೆಸರಿ ಟ್ರಬಲ್ ಕೊಡ್ಬಾರ್ದು. ಅದಕ್ಕೆ ಏನಾರ ಮಾಡ್ಬೇಕು. ಈಗ ಅವರು ನಮ್ ಸಲುವಾಗಿ ದೇ ವಿಲ್ lay down their lives. Okay, if they have retired alive, for that they cannot be punished because enemies did not kill them.
I'm an army officer's son, my lord, so.
In one of the case, my lord, I am appearing, my lord. 40 years back, a land for personal, army personnel has been allotted a land in Channapatna Taluk, my lord. Now, they claim that it is a forest land, you go out of they have initiated the proceedings. 40 years back, land was allotted to army personnel. That case is pending before this Honorable Court.
ಫಾರೆಸ್ಟ್ ನಮ್ಮ ಡಿಫೆನ್ಸ್ ಪರ್ಸನಲ್ ಅನ್ನ ಬಹಳ ಗೌರವಯುತವಾಗಿ ಪ್ರೀತಿಯಿಂದ ನೋಡ್ಕೋಬೇಕು. ಯಾಕಂದ್ರೆ ಅವರು ದೇಶದ ಗಡಿ ಕಾಯ್ತಾರೆ. ಆಮೇಲೆ ಏನ್ ಗ್ಯಾರಂಟಿ ನಾಳೆ ನಾವು ಬಂದ್ಮೇಲೆ ನಮ್ಮ ಸಮಾಜ ಸರಿ ನೋಡ್ತದೆ, ಸರ್ಕಾರ ನಮ್ಮನ್ನು ನೋಡ್ಕೋತದೆ, ಏನೋ ಒಂದು ಪೀಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಕೊಡ್ತದೆ ಅನ್ನೋ ಅಜಂಪ್ಷನ್ ಮಾಡ್ತಾರೆ. ನಾವು ಆ ರೀತಿ ಮಾಡಿಬಿಟ್ರೆ ಅವರು ಕಮಿಟ್ಮೆಂಟ್ ಟು ದ ಕಾಸ್ ಆಫ್ ನೇಷನ್ ಡೈಲ್ಯೂಟ್ ಆಗಿ ಹೋಗ್ತದೆ. ಬೇರೆ ದೇಶದಲ್ಲೆಲ್ಲ ನೋಡಿ ಅವರು ಸೋಲ್ಜರ್ಸ್ ಎಲ್ಲ ಏರೋಡ್ರೋಮಿಗೆ ಏರ್ಪೋರ್ಟಿಗೆ ಬಂದ್ರೆ ಬೇರೆಯವರೆಲ್ಲ ಎದ್ದು ನಿಂತ್ಕೊಂಡು ಚಪ್ಪಾಳೆ ಹೊಡೆದು ಅವರಿಗೆ ರೆಸ್ಪೆಕ್ಟ್ ತೋರಿಸೋದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ನಮ್ಮಲ್ಲಿ ಯಾವ ರೀತಿ ಸಿಪಾಯಿಗಳನ್ನ ಟ್ರೀಟ್ ಮಾಡ್ದಂಗೆ ಮಾಡ್ತಾರೆ. ಇಟ್ಸ್ ನಾಟ್ ಎ ಗುಡ್ ಕಲ್ಚರ್.
Very difficult.
ಸೊಸೈಟಿ ಅಂಡ್ ಸ್ಟೇಟ್, ಸೊಸೈಟಿ ಹೆಂಗಾರೆ ಇದು ಅಟ್ಲೀಸ್ಟ್ ಸ್ಟೇಟ್ ಆಫೀಸರ್ಸ್ ನೀವು ಅವರು ನೋಡ್ಕೊಂಡು ಏನ್ ಕೊಡೋದಿದೆ ಕೊಟ್ಟು ಬಿಡ್ಬೇಕು. ಆ ರೀತಿ ಮಾಡಬಾರ್ದು. ಅದೆಲ್ಲ ಪಾಪ ಕಟಿಗಳು ಅಂತ ಪಾಪ ಬರ್ತದೆ.